May please not.
Yes,
I beg to mention item number 1.
yes.
The appellant has directed me to withdraw this appeal.
Mr. Bhatt, present counsel for the appellant on instruction 6 to withdraw this writ appeal. In view of the submission made, writ appeal is hence dismissed on withdrawal.
Obliged, Lordship.
And Mr. M. Bhatt, counsel for the appellant, and Mr. R. V. Yadav, counsel for the respondent number
1 to 4.
1, 2, 4. Then this will follow. Okay.
Obliged.
Number 7.
Yes.
This is a matter where an order of preventive detention is under challenge. Now, if your lordship will kindly just see the facts that led to this order, your lordship will be able to appreciate as to how this order probably is not contemplated under law. If I take your lordship to page 28. Page 28. Now, this is a letter of 3rd of May, 2023. Now, this is to the Deputy Commissioner. The subject is permission for construction of Statue of Honesty as a tribute to our hero, Sri Gyam Padang, at 6 kilo near vegetable vendor adjacent to NH 415. I'm just reading that for ourselves. It is with deep sadness and heavy heart, we inform you that Sri Gyamang Padang, the whistleblower of the APPC scandal, passed away on 3rd of May 2023 at 8:10 a.m. due to prolonged illness. The entire state of Arunachal Pradesh, may I read that also?
Yes, yes.
Yeah. The entire state of Arunachal Pradesh is aware of his bravery and courage that he has shown to make Arunachal Pradesh a better state. He is one who ignited the fire of revolution among the youths to fight.
What is the necessity for erecting a statue of honesty?
No, sir.
What is the necessity for erecting of a statue of honesty?
That necessity would be something that the public sentiment and the public would know. Public sentiment, because of the public sentiment, because lordship knows regarding that APPC scandal.
We don't know.
So the issue that has happened here is that because of this APPC examinations, there was some information that there has been paper leakage. Now, leading to that, there was an FIR filed by one called Gyamang Padang. Now, based on that FIR, that examination was cancelled, and therefore a lot of incidents have happened. Now, therefore, this person has been regarded as a hero by all these APPC people, the people who are fighting against this illegality or the corruption that has happened.
You have to carry the honesty in your heart and mind, not in the statue.
Yes, Lord.
Anyway, proceed.
Yes.
Yes, Gary, you wanted to say anything?
Is that because the RT during the leakage, paper leakage of the issue, raised by the.
You come to the mic.
Yes.
Please come on the mic.
During that time, Your Lordship, because other person is offered to the Gyamang Padang for case, even then Gyamang Padang is not ready to the offer by the someone's, and he wanted to clear the reformation of the Public Service Commission, that's the highest institution of the states. That is why he is not ready to the offer of the other persons. So he wanted to the given punishment to the accused person.
We don't know.
That is why
Anyway,
students are desired to the honesty statute is record and his last wishes.
anyway, we don't know about this. Let us stick to the case.
Yes, Lord. So, leaving aside the fact as to why the Statue of Honesty was required, what I am here before Lordship is that based on that particular requirement that they wanted to build a Statue of Honesty, there are certain incidents that happened, which ultimately led the Deputy Commissioner to pass this order of preventive detention. My entire endeavor before Lordship would be to show that it was not a situation that would have required invocation of the Apu Act. So just for that regard, I'm showing these documents just to indicate that there was not that kind of a situation. So I'm just not going through the entire document. 3/5/2023, a permission was sought for. It is not that the people have directly gone ahead and they have used their might and shown that yes, we are going to go ahead. Procedure was followed, and what they said was, please give us the permission for construction of a statue of honesty. So this was the application that was made. Just the last paragraph I am reading. Therefore, your good office is requested to grant permission to construct statue of honesty of the state hero Gyamar Patan. So an application was made on 3rd of May. Now, if your lordship will come to page 30, this application was forwarded. This application was forwarded by the deputy commissioner. So a process was on. It was not that it was directly rejected, but it was forwarded to the Principal Secretary Home, Arunachal Pradesh. Forwarding of representation of PAN Arunachal Joint Steering Committee and thereof regarded. The last line is, therefore, it is requested that necessary government approval be obtained if deemed fit. So the matter was put to active consideration at the government level. Now, there was an incident that there was an order of detention that was issued against Techipuru earlier also. That was set aside. This judgment is at page 31 and Annex 3. I'm not troubling your lordship with the judgment as of now. Now, if your lordship will come to page 51.
Yes.
Lordship has seen on 3rd of May, a permission was sought for. Now on 24/7/2023, update on the permission for construction of statue of honesty as a tribute to our ancestors hero. With reference to the subject cited above, it is to inform that a representation was presented before your good office on 3rd of May, for which we would like to know the updates of the same. Therefore, your office is requested to give an update of all the developments of the aforesaid mentioned. Furthermore, it is to inform you that a social service program would be conducted at a demarcated location on 25th July 2023, and the family members and well-wishers of the whistleblower, Sri Gyamar Patan, the consent and cooperation of the good office would be appreciated and a positive reciprocation is anticipated from your end. So what we were saying on 24/7 is that first we are asking for an update as to the regarding the permission for construction. Number two, what we were saying is on 25/7, we wanted to do social service. Social service, as I have been able to gather, the meaning of social service here in Arunachal Pradesh is to do cleanliness drive.
Social service in Arunachal Pradesh has a different meaning than the meaning it has elsewhere in the country.
No, social service in the form of giving donation, going to some child orphanage and all those things. Social service can be of various nature also. So this particular social service was for cleanliness drive. This was for cleanliness drive, to clean the area, cleanliness drive. My instructions as far as it goes also. So I asked them, what is the social service all about? They said we wanted to go for a cleanliness drive in that particular area. So, and they were asking for a permission for that.
Yes.
Now, after this, immediately at page 52, section 144 CRPC has been issued. So my argument is, we were only asking permission, nothing of that sort had happened. We were not giving any warning. But suddenly, the DC in the most harshest of manner proceeded to issue 144, number one. And the impugn order is at page 54. On the same date, detention orders have been issued against Techipuru.
Yes.
I have to read this order. On the same day, 25 July.
Yes.
And Lordship, I must place it on record. No social service activity took place there. Once the orders were out, nothing happened. So these activities never took place. I'm just reading the order. Whereas Sri Techipuru, chairman of PAN Arunachal Joint Steering Committee and others, have submitted an application to the office on 24/7/2023, seeking update of the representation dated 3rd of May regarding permission to construct statue of honesty as a tribute to our hero Gyamar Patan at 6 kilo vegetable vendors adjacent to NH 1415. And whereas by aforementioned application, they informed this office that a social service program at the demarcated location on 25 July 2023 is proposed by the family members and well-wishers of the whistleblower, Sri Gyamar Patan. And whereas the representation dated 3rd of May submitted to this office for construction honesty of statue of honesty as a tribute to Sri Gyamar Patan has already been submitted to the government for further decision. And whereas before holding any program, prior permission is to be obtained from a district administration for various arrangements, traffic, magistrate, police, deployment, and to avoid income to the general public. And whereas the land proposed for construction of the statue of honesty by Sri Techi Puru, chairman of the Pan Arunachal Joint Steering Committee, and others belongs to the Highway Authority. And whereas in respect of the application dated 24/7/2023, the district administration Itanagar has directed Sri Techi Puru, chairman, and Tadak Nalo, vice chairman of Arunachal Joint Steering Committee, to obtain NOC from the Chief Engineer, Highway Department before conduct of any social service program, since the area proposed for the program construction of the statue falls within the jurisdiction of the highway authorities. And whereas Sri Techi Puru, chairman Pan Arunachal Joint Steering Committee, and others are trying to grab government property without authority and permission from the competent authority, which is illegal and unlawful activity as prohibited under the law. And whereas Sri Techi Puru, chairman Pan Arunachal Pradesh, has through media instigated general public to participate in the social service with an ill intention to grab government property without consent of the competent authority, which is illegal and unlawful activity as prohibited under the Act. And whereas in accordance to the government notification such, the Arunachal Pradesh Unlawful Activities Prevention Act has come into force with effect from 26 January 2015. And whereas Techi Puru, by involving himself in unlawful activities, have become unlawful person under section 211 of the Arunachal Pradesh Unlawful Activities Prevention Act. And whereas I, Sri Talokotam, IS District Magistrate, Itanagar Capital, in exercise of the powers conferred under section 3(1), I'm satisfied that Sri Techi Puru is an unlawful person, association with unlawful activities, and hereby directed that he may be detained for a period of 12 days with the view to prevent him from taking illegal possession of the government properties and construction of unauthorized structures thereon in the Itanagar Capital Complex. The Superintendent of Police is thereby directed. Now, if your lordship will see, what was the aggression from our side? There has to be some element of aggression from our side for a district administration to think that there will be some law and order situation now. That aggression was never there. We were simply writing letters asking for permission. And all that we had said was for social service. Now, this property grabber, that is the basic contention of the Deputy Commissioner, says that in the name of social service, we are trying to grab property, government property. That is a speculation. There has been no credible evidence or material on record to indicate that there is an intention of grabbing government property. So therefore, that satisfaction that he must have derived, which the records will very well show before your lordship, what was the satisfaction derived by the Deputy Commissioner to come to this finding that there may be property being grabbed in the name of social service, and therefore I need to put him under preventive detention. That, in my humble submission, is absent and missing in this case, and therefore there could not have been an order passed under Preventive Detention Act. There were other acts, lordship. IPC 441 trespass, criminal trespass is there. Arunachal Pradesh Public Premises Eviction Act is there. He did not apply those acts, but he directly went to the harshest of law, that is preventive detention. And another aspect that I would like to show before your lordship is that the definition of property grabber. If your lordship will take up the Apu Apa Act, lordship will see what is the definition of property grabber. If your lordship will see the definition of property grabber, then lordship will find that under speculation.
What is the act?
The Arunachal Pradesh. Arunachal Pradesh Unlawful Activity Prevention Act, lordship. Page 155, 155. This is the Arunachal Pradesh Unlawful Activities Prevention Act 2014. Now, under this act, lordship will find at page 157 the definition 11, property grabber. Page 157, property grabber. Subclause 11. Lordship has got that. The definition is property grabber means a person who illegally takes possession. I'm just stopping at that, lordship. Property grabber means a person who illegally takes possession. That means an act of possession has to take place. Philosophy will see the definition. property grabber means a person who illegally takes possession. That means a physical act of taking possession has to actually happen. The possession must have fructified. The possession must have come into existence. But here, if your lordship will see the impugned detention order, what does the district magistrate say? He
Yes.
says, Sri Techipuru are trying to grab government property. And therefore, he says that he comes under unlawful activities. But if the definition of Apu Apa Act has to be looked into in a proper perspective, the Act defines that the person must have committed the crime of taking possession of that particular land, government land. Only then this provision could have been attracted. But here is a case where a deputy commissioner has speculated that in the name of social service, land may be grabbed. So therefore, that understanding in my humble submission is wrong, Lordship. If you are trying to invoke the Apu Apa Act, you have to go by the definition as provided under that particular act. Now the act says the particular incident must happen. It says means a person who illegally takes possession. It doesn't say illegally wants to take possession, is going to take possession, takes possession. And here, if your lordship will see that page 54, the impugned order, the third last paragraph, what the deputy magistrate says, are trying to grab government property in the name of social service. So in my humble submission, in these facts of the circumstances, the Apu Apa Act, more particularly by invoking the provision of property grabber, this particular detention order could not have been issued. And leaving apart that also, some circumstantial evidence has to be there that yes, they are going to create aggression, they are going to create law and order situation. Nothing of the sort that happened. It was a peaceful movement. They were seeking permission. They were asking, can we go for social service there? He could have very well said, no, you cannot go for that. End of the matter. He could have said, we are going to impose section 441 of the IPC, criminal trespass. He doesn't do that. He directly on the next date immediately passes an order of preventive detention, which is the harshest of law in my humble submission also, because it's preventive detention. So in that
Yes.
view of the matter, Lordship, the imposition of detention under the present act could not have been come into play, and therefore this order is bad. If the records are called for, Lordship will very well be able to ascertain whether the satisfaction as is record to be derived under section 3(1) by the district magistrate, was it in the most justifiable manner taken or not?
Yes.
So that will be my subject. Factual circumstances, Lordship has seen. Factually, there was no element of aggression. We were writing letters. That is one aspect of the matter. Second aspect of the matter was that if your Lordship is the impugned order, it's
Are you praying for an interim order or not?
yes, Lordship.
Huh?
I am
Okay.
praying for that.
Yes.
Because my argument is
On what ground?
on the ground that the impugned order could not have been passed by invoking the Apu Apa Act, because he is taking recourse to the definition of property grabber. Property grabber definition says the act has to happen, take possession. But the impugned order says he was trying to take possession. So he was speculating that he might take possession. So therefore, this definition that has been brought into the particular order, definition on the impugned order is not correct. On that aspect.
What is your ground for an interim order? You said that if we call for the report, we'll be able to examine whether the satisfaction has been
Yes,
correctly
that
reached
is-
or not.
that is for the final.
That is for the final.
That is for
Are you praying for an interim order today?
yes, of course.
On
And-
what?
On the ground that I am yet to be apprehended. I have not been apprehended. The order has not come into force, number one.
Yes.
And number two would be that this order is without authority and jurisdiction, because in the fact of the circumstances, this act could not have been applied.
Then
Because-
why have you come so late?
We were trying to find out avenues of somehow trying to tackle with this order.
Huh?
25 July, Lordship. Today is 7th, today 8th, today is 8th. Not that also, Lordship. We were trying to avail alternate remedies if possible, whether some good sense would prevail upon the deputy commissioner, this order is recalled. But since nothing has happened, there is no efficacious remedy but to approach this honorable court. So we are before this honorable court.
Okay. When no good sense prevails upon anybody, then only you come to
We
this court.
demanded justice. We
It
demanded,
appears, it looks like you have approached this court very reluctantly.
not like, not like that also. This is the last resort we have. High courts are the last resort.
Can we
Last
pass,
time also-
can we pass a stay order?
As long as the order is not put to effect, and if the order is without authority, your lordship has got plenary powers under section 226 to pass an order of stay.
Yes, Tape.
If matter will be taken up there tomorrow, so I'll come with the request.
Yeah, sure, tomorrow.
No, it prima facie looks like
Lordship,
that there is no occasion to issue this order. It is no nexus with the act,
Lordship, this is not,
object of the act.
this is not a simple act of two few persons, Lordship. What they are doing is they are inciting the people to participate.
We'll examine. Can we pass a stay order?
Therefore, this is Lordship, pre-education's petition law.
Pre-education petition. You don't execute it. You wanted a preventive detention of him for 12 days. 12 days has gone by. Situation has changed. There is no any imminent danger also.
12 days, Lordship, the issue is still alive, Lordship.
Huh?
Issue is still alive, Lordship.
Issue is alive. But when this act can be invoked, under what circumstances?
Lordship, circumstance has been already prescribed in the law, Lordship.
Let us see. You have referred to the petitioner by involving himself in the unlawful activities
No.
have become unlawful person as per section 211,
That is
which
so-
actually is not unlawful person, but it is
property
section 211 is property graver of the APP Act. Okay,
Lordship.
let us see what is section 211 is a property graver. Means a person who illegally takes possession. Either and there have been so many encroachment on the premises of the government quarters, which would attract this 211. But you have not issued any detention order to any of the property gravers as defined under this act. So it looks like there was no occasion to, is not it?
If Lordship read with the other Lordship, the circumstances as cited in the.
We'll go with the order.
No, I'm on the order only, Lordship.
Yes.
Order, Lordship is reading, Lordship, the page 55, Lordship.
That is the final decision ultimately.
Yes, this is the ground on which you appears to have detained.
211 is the ground that he took a decision of preventive detention.
There has been no any, he is yet to grab the property. He has made an attempt. You have prevented by issuing this order. 12 days have gone by.
So therefore, my submission is still that, Lordship. Issue is alive, Lordship. So therefore, I'm seeking for the short date, Lordship.
No, we'll examine. We always give the government adequate time to respond. It is from a person to us, it looks like the provision we have invoked is the property graver, which has been defined as whoever illegally takes possession of. There are many instances. Every day we are dealing with this eviction of the petition on the Eviction of Public Premises Acts, encroachment, this, that.
In
But
fact,
never you have issued in this kind of act. This act is for some other purpose.
In fact, there is a
Otherwise,
particular
lawsuit-
act for public premises
Otherwise,
eviction.
laws is circumstances law is cited in the laws in order itself laws.
We have to go by the ground. I mean, the ground is taken. for the-
Sri Teti Kuru, Chairman, Fund on the Joint Steering Committee, through social media has instigated the general public to participate in the social survey with an ill intention to grab the government property without consent from the competent authority, which is illegal and unlawful activities as prohibited under. This is also circumstance law.
Understand? Heard Mr.
Yes, sir, my lordship.
Counsel for the petitioner and Mr. S. Kapil Lal, senior government advocate for the state. This writ petition is directed against the order dated 25th July 2022, issued by the DC District Magistrate Capital Itanagar. By number so and so. As at page 54. Which is reproduced here in below. Full stop. From perusal of the impugned order dated 25 July 2023, issued by the DC District Ministry Capital Council Itanagar, it appears that petitioner has been directed to be detained for a period of 12 days with a view to prevent him from taking illegal possession of government properties or construction of unauthorized structures thereof in the Itanagar Capital Complex, by stating that the petitioner, by involving himself in the unlawful activities, had become unlawful person as per section 211 of the Arunachal Pradesh Unlawful Activities Prevention Act 2014. Full stop. Section 211 of the APPU AP Act 2014 reads as under 211, property graver, etc. Full stop. According to the petitioner, an application dated 3/5/2023 was submitted to the Deputy Commissioner General of Papumpare District, seeking permission for construction of what is called, within inverted comma, the statue of honesty, as a tribute to, just a moment, the statue of honesty. To at within brackets 6 kilo near vegetable vendors adjacent to NS 415. The aforesaid representation dated 3/5/2023 submitted to the Deputy Commissioner Eastern Kabul District, the Deputy Commissioner had forwarded it for the consideration, forwarded it to the Principal Secretary Home, Government of Arunachal Pradesh for consideration by his letter dated 3rd May 2023 and by letter dated 3rd May 2023 by number sense at page 30. While the representation submitted by the petitioner was under consideration of the government, the petitioner submitted yet another application to the Deputy Commissioner Itanagar on 24/7/2023, seeking an update on the permission for construction of the statue of honesty within inverted comma. What is called statue of honesty within inverted comma? And thereafter also informed the Deputy Commissioner that a social service program would be conducted at the demarcated location on 25th July 2023. Full stop. To prevent the social service fixed on 25th July at 6 kilo near vegetable vendors adjacent to NS 415. The Deputy Commissioner by the order dated 25th July 2023 issued under memo number at page 54 by the DC District Magistrate had promulgated Section 144 of the CRPC, thereby prohibiting the gathering or assembly of 3 or more persons, exempting government officials and security forces on duty within the radius of 500 meters around the 6 kilo near vegetable vendors with immediate effect till further order. Pursuant thereto, it is the case of the petitioner that no social service took place at 6 kilo, etc., vegetable, etc. And there has been no land grabbing of the designated place either by the petitioner or any other person. Person. The impugned order of impugned order dates back to 25th July 2023. Today is what?
Today is 8.
8. And thereby more than 12 days have passed by. Since the impugned order dated 25th July 2023 was issued by the DC District Magistrate, Capital Council Itanagar, by which impugned order detention for a period of 12 days was sought for of the petitioner with a view to prevent him from taking illegal possession of government properties also. Upon consideration of the contentions raised, let notice be issued within every 4 weeks. As Mr. Tapin and Councilman Sir has accepted note on behalf of all the respondents. All the respondents, no formal notice need be issued. However, extra copies of the writ petitions be furnished to him during the course of the day. First, considering the nature of contentions raised by the petitioner is highlighted herein above, and also having perused the provision of section 2, 8, 11, 12 of the Arunachal Pradesh, as well as section 3(1) of the Arunachal Pradesh Unlawful Activities Prevention Act 2014. And also having taken note of the fact that more than 12 days have passed by since the impugned order dated 25th July, etc., was issued by the Deputy Commissioner Chancellor. And that the status of the land where the social service was proposed by the petitioner has not been changed in any manner, either by the petitioner or by anybody. In the interim, it is provided that the impugned order dated so and so, issued by so and so, by number so and so, shall remain established. At the same time, the petitioner shall also not indulge in any activity relating to the erection of what is called statue of honesty at 6 kilos so and so. Without appropriate permission that may be required under the law is taken from the appropriate and competent authority of the state. So please state after 4 weeks.
Shorter date can be given because on the basis of regulation can be disclosed.
What?
Shorter date.
What sort of that? We have other important matters also.
Let them file their affidavit.
Huh?
Let them file their affidavit.
Yes. If there is a change of situation requiring urgent disposal, you may make a mention. But as on today, we don't find anything.
Deeply obliged, Lord. Deeply obliged.
We'll be filing our affidavit very shortly back.
The one sentence will add, it has been submitted that the impugned order has not been executed. No?
Yes.
Okay. That's somewhere. Okay. All right. Item number
2.
2. Yes.
Father, we'll be filing our affidavit very shortly.
Who is the counsel for the petitioner?
In the course list, none has been mentioned.
No name has been shown.
Yes, Father.
Oh, who is this I Chaudhary?
Oh, earlier, our AG,
No, but I Chaudhary is learned counsel. It's some different Chaudhary, I think.
I believe it is.
Not the senior
our-
counsel Chaudhary.
It was our AG.
Okay, yeah. Here. No. Idris Chaudhary. Okay. Oh, he is the counsel for the petitioner, but his name has not been shown because his name is not registered in the CIS. So the CIS system cannot generate. What is to be done? He should have some local counsel here.
Otherwise, notice may be issued to the petitioner. Ma'am.
What is the matter about otherwise?
Otherwise, their allegation is that without floating tender, works have been awarded to the private respondent.
Okay, you want to file affidavit?
Yes, ma'am.
Okay, all right. Non-abuse for the petitioner. Nor the name of learned counsel representing the petition has been shown in the cause list poster. It has been indicated in the office note that the learned counsels representing the petitioner, namely Idris Chaudhary and Torikul Hussain. The name of Sri Idris Chaudhary and Torikul Hussain have not been registered in CIS, and it is because of that the name of the learned counsel representing the petition would not be shown in the cause list. Also, since Mr. Attorney AG is praying for time to file counter affidavit listed after 4 weeks to enable filing of the counter affidavit.
Always.
Number 3.
Oh,
May it please the Lordship. Lordship, in this matter, the scanned copy of the LCR has been received by the registry. Paper book may be called for and amicus curiae may be appointed.
Nivo, you are appearing for? Okay, respondent number 2. LCR received.
Yes, sir.
Okay. What is the sentence?
Life imprisonment with life imprisonment, Lordship. A fine of 50,000 or 5,000.
Life imprisonment. Okay. All right. Mr. Miss APP for the state and Mr. M. Levo, learned counsel for the respondent number 2. Victim or informant? Informant. Also. Office note that says that LCR has been received as indicated in office note dated 12/6/2023. Learned the registry shall prepare the paper book and okay. Shall prepare the paper book and list it thereafter. First off. Since the appellant, since this is jail appeal, na?
Jail appeal.
Since this is an appeal prepared from the jail, we appoint Mr. Harvey Lampu as the amicus curiae to represent the appellant. First, after the paperwork is prepared, registrar shall furnish a copy of the paperwork to all the learned counsel representing the parties. List it accordingly.
My lord, the matter of partnering before the lordship is, my lord, partnering to the, my lord, let's say, so for the implementation of 14 and 15 Finance Commission, my lord.
My lord,
Body involving is, my lord, 121.
I believe here, my lord, the standing counsel for the IMC, Mr. T. Jammu,
IFC?
IMC.
Oh,
Municipal.
municipal.
Yes, sir. He represents 3 to
Three,
6.
yeah. Three to
He,
represent three.
his affidavit will be required now.
3, 4, and 6.
He had,
3, 4.
he had appeared on the last occasion.
Yes,
Yes,
He
his name
appeared
has
in the
not been
last
shown in the process.
He is the standing counsel.
Standing counsel for the IMC.
his name may be reflected in the court, his mark. His line may be.
You, OMO is for ULB means which respondent? Respondent number 2.
2 and 5.
I have not been made part.
In the coastal, you have not been made a party?
Yes, but in the prayer portion, I have been added, in prayer portion, my name has also been this
What is your name?
director, urban local body.
You are not representing the secretary. Secretary,
No,
Department of Town Planning and ULB. Director of the. Yes. Why have you done that? Director, urban local body. Is not a party.
My lord, it seemed the secretary department, town planning and the ULB, once upon a time, my lord, it was under the same, my lord. And director department of town planning is my son, my lord, made this party.
So you
I-
withdraw this PR,
In fact,
file afresh.
respondent number 4 also, the municipal corporation.
See, unless you properly added the respondents,
My lord, that is there.
no
My lord,
effective adjudication can
my
be
lord,
made.
as part of withdraw, my lord, I may be allowed to, my lord, amend the petition. My lord.
That
By
is- that
adding
is-
the report.
That is up to you. Then you file amendment application,
My lord,
okay?
I prepared the amendment.
Okay, how much time?
My lord,
On the
will be-
prayer of Mr. C. Morin, another council for the petition listed after 2 weeks.
My,
Okay.
Your Lordship, actually, this matter has been looked after by my learned colleague, Your Lordship. He is unwell, so
Okay,
this matter may be taken up after a week, Your Lordship.
okay, after 2 weeks.
It may be taken up, the appellant is in the jail for more than 1 year.
What is the offense?
302, madam.
302.
Yes.
Eyewitness is there.
Madam?
Eyewitness is there.
No, madam, it's, but totally, madam, but the manner in which the conviction was done, madam, totally, madam, not as per the procedure, madam. They only based on the evidence produced by the alleged victim at the fake end of the trial, my lord. Based on that documents, conviction has been done.
Okay.
That is not allowed, my lord, under section 173 CRPC.
All right.
New evidence, my lord.
Oh,
So it may be Tuesday, next Tuesday, my lord.
on the prayer of learned counsel for the part listed after a week.
After a week, your lordship.
Okay.
Deeply obliged.
This challenging the rule, Lord.
Ah.
The state council was supposed to get the instruction. Since the rule is under framing,
Yeah, why it has come up for hearing?
I don't know, Lord.
Affidavit is fine.
They have filed the affidavit, but during,
The file, my lord, then the last time we obtained the instruction on 24th April. Then as per the department instruction, the matter has been placed before the AR department. The proposed amendment rules, my lord.
Oh, you are proposing, you are
Yes.
proposing an amendment.
Already
Correct.
started, my lord.
Okay,
So now matter is before the AR department, they are scrutinizing, my lord.
we'll close it.
no,
Okay,
because
So it
Here-
will come after 4 weeks, my lord.
okay.
the problem is two sets of rule where unequals have been brought to equals.
Add Mr. Titi learned counsel for the petitioner and Mr. R.S. Nawal learned additional advocate general who submits that proposal for amendment of the rule which is under challenge in this writ petition has already been initiated by the government. Was in view of the above, let this matter be listed after
4 weeks,
8 weeks,
4 weeks.
6 weeks.
Item number 1 to 4 and then 9 and 10.
Yes, sir.
In the first 3, 1 to 4, my understanding that is
Okay. One, this 1 to 4 on 21st.
21st.
Okay.
Great.
On the prayer of the council for the party listed on 21st,
Then 9 and 10.
9 and 10. 9 and 10 also, 21st. Okay,
No.
huh? Okay. Why don't you fix these 2 items then on some other day? Because you are fixing 4 cases on 21st. Maybe earlier also, whatever it is,
In
or
that case, my lord,
what is the, what is this matter? Arun? 9 and 10, 9.
this pertains to district-based reservation.
Okay. When do you want?
In that case, though, after that, my lord, next week.
All right, 21st. Okay.
There will be a 21st week, just,
Okay.
if necessary, I will stay back for pound.
Yes,
May I made a mention item number 16.
yes.
Madam, here I am for the private respondent, madam. I need to file my affidavit. So therefore, madam, 4 weeks time may be granted, madam. In the meantime, we'll file a bit. Item number 4,
You are for the respondent.
private respondent. I have taken the counsel for the petition, madam.
All right.
BP
Mr.
size the counsel for the petition.
Sorry, M. Kato, Learned counsel, which respondent?
Private respondent, madam.
Or the
Newly pleaded.
Private respondent,
12.
listed after 4 weeks
Madam.
for filing of the counter affidavit.
Right.
Yes.
Deputy.
Lordship, I beg to mention item number 18, Your Lordship.
Yes,
Here respondents have not yet filed the affidavit.
yes, yes, Kato,
2 weeks.
4 weeks time. 6 weeks time. Have you received instruction?
Yes, my lord.
Oh, you have received instruction, okay.
2 weeks.
Miss M. Anju, learned counsel for the petitioner, and Miss M. Kato, learned counsel, learned DSGO, who submits the Paramount's comments for filing of a counter affidavit have been received, for which he pressed for and is granted 2 weeks time. Listed after 3 weeks.
Lordship, interim may be continued.
Interim order passed, elders shall continue till the next date listed.
Obliged.
Wait,
Ah,
beg to mention item number 26, ma'am.
26.
Yes.
Okay,
Can this be taken up next week? Ma'am?
okay, after a week, on the prayer of Mr. Deepan and competition, listed after a week.
Your Lordship, item number 28 may be adjourned for today, Your Lordship.
Which one?
Item number 28.
28.
Rana and others versus State of AP. 28.
Yes,
Your Honor, learned counsel Shri H.K. Duri, he informed that he is having unable to appear before this court due to some personal problem, Your Honor, and it may be listed after 16 August of this month.
okay, all right. The prayer of, on the prayer made on behalf of Mr. S.K. Devi,
Yes, Your
there is
Lordship,
counsel for the petitioner, listed after 2 weeks.
2 weeks.
Okay, all right.
My lord, I beg to mention item number 21. The conducting counsel of this case is unwell today. So matter may be adjourned today and this after 1 week.
You are for the petitioner,
Petitioner, yes.
who is for the respondent?
Respondent,
Government has filed affidavit.
yes, I have taken the consents.
Just. What is the matter about?
Yes.
What are you challenging in this petition?
This is no regarding no confidence motion.
No convenience motion.
Yes. Thank you.
Affidavit already filed. When do you want?
14th of this month.
14 of this month?
Yes. Next.
Okay, after, on the prayer made on your petition, listed after a week.
My lord, I beg to mention item number 14.
14,
Yes, my lord.
yes,
My lord, here in this case, I may read as respondent number 4, private respondent number 4. This matter was taken up by Mr. N. Ratan, but now he is unable to take up. So this matter is taken up by some other council. So some time may be given.
you are making mention on whose behalf?
I mention on behalf of Mr. N. Ratan,
Then you
for the
take this
respondent
case.
number 4.
Then you take up this case.
My lord, I'm not
Ratan-
have any contact with this private respondent number 4.
Yes, who is for the petitioner here? Anybody? What is the matter about?
Matter is about, my lord, is encroachment of land. The petitioner has challenged the impugn order of the ADC and the DC
Okay.
eviction order.
On the prayer of Mr.
Timite, my lord.
T. Mitte. You are not there in the case.
Yes, my lord, not in the case.
Who was assisting Mr. Ratan in this case? See, Mr. Ratan has become now very old additional advocate general.
Yeah.
Now this kind of the client had a sufficient time to engage another counsel. Who was assisting
One of
you?
the
T. Tagu.
T Tagu was
Where is
there.
Tagu?
They are not here today.
No.
Rest of the.
Okay,
On behalf of Peter,
on behalf of T. Tagu, listed after 2 weeks. Yes.
much obliged.
My lord, I'd like to mention item number 6.
6.
Senior counsel is having a personal difficulties, therefore matter may be adjourned today.
What is the matter about?
Job termination.
Huh?
Job termination.
Termination of service?
Yeah.
Tarak, you have filed affidavit? Okay. After
3 weeks.
3 weeks? Huh?
Yeah.
On the prayer of Miss, your name?
And Loy.
L. Loy, learned counsel for the petition. With the consent of Mr. G. Tarak, learned counsel, standing counsel for the Honorable.
Interim order earlier passed may be continued.
Oh, there is a stay order. Connected matter. You can give the number, we can list it together. Okay, yes, tapi ni mana? 15? No. Can you furnish during the course of the day? No. Oh. Okay. Then we'll say after 2 weeks, 3 weeks. Okay, 3 weeks. With the consent of Mr. G. Tarak, when council for the will be listed after 3 weeks. Interim order pass earlier shall continue till the next date of listing. 15. Yes. Okay. What is the matter? You have received instruction to file affidavit. Mr. Tabul, counsel for the senior government advocates submits that instruction to file contributor has been received, for which he pressed for an example 3 weeks time. Listed after 3 weeks. Okay.
May I? Your Lordship?
Yes.
Your Lordship, this is a petition filed before this Lordship for issuance of a direction to the respondent parties to release the service benefits of late Tabum Koyu. Your Lordship, the petitioner is the daughter. Your Lordship, the petitioner is the daughter of Tabum Koyu, who was working as a Khalsi in the Brahmaputra board. And she was expired on 8/2/2022. As being the legal heir of the legal heir, the petitioner claimed the service benefits of her late mother. Your Lordship, the respondent authorities are causing delay in paying, although the respondent had released that CPF amount of rupees 14 lakhs to the petitioner in the month of October 2022. Lordship, despite repeated requests, the respondent are reluctant to release the service benefits in respect of the petitioner's mother. Your Lordship. Your Lordship, on dated 5/6/2023, I had submitted a representation before the respondent for release of the remaining service benefits. However, there is no any response from the respondent parties. And my only and simple prayer before this Lordship is to direct them to release the remaining service benefits of late Tabum Koyu.
All right. Yes, Kato, you appear for all.
No, my lord, I am for the respondent number 1, my lord.
One only.
Respondent, my lord, 4. Chairman, Brahmaputra board.
You cannot represent board.
That is basically no instruction regarding this board.
Just a minute. Where is this board? Brahmaputra board located?
Your Honor, it's the where this
Assam.
yes, it's located in Assam, or it's also located in your Arunachal. The way this are working was it's a rowing division under district lower division.
Rowing division.
Yes.
You were posted at rowing.
Yes.
As what? Or you means who?
I'm for the petitioner.
Your father.
My mother.
Okay, mother was okay. He retired or what?
Actually, Your Honor, she expired while she was in service.
While she was in service. She was working as what?
She was working as Khalsi Which is,
Khalasi.
yeah, generally, basically a group D employee. Comes under group D.
All right. Mr.
E Pumbo.
Pumbo. Pumbo. Economic Council for the petitioner, and Mr. D. M. Carter, and the BSGI for the respondent number 1. Issue notice, returnable in 4 weeks. As Mr. Carter, and Council, and BSGI has accepted on behalf of R1, no formal notice will be issued. Poster. Extra copy of the petition shall have furnished to him during the course of the day. The steps for service of notice upon respondent 2 and 3 be taken by registered post with AD as well as the using process within a week. List it after 4 weeks.
May I please, my lord?
Yes.
My lord, the petitioner herein is a driver posted at the District Agriculture Office, Bomdila. By way of this writ petition, the petitioner is assailing the legality and validity of an impugned transfer order, which is at Annexure 1, page number 11, dated 31/5/2023. Basically, the petitioner is challenging the transfer order only on 2 grounds: medical ground as well as on the humanitarian ground.
Page 11.
Page number 11, Annexure 1. This is the impugned transfer order.
Yes.
So till date, this transfer order has not been given effect to it. There was no reliever also assigned. And already a month has been passed. There's inference can be drawn that there's no administrative exigency also. To this effect, the representation was also filed before the Secretary, Department of Agriculture, which is the next page.
Agriculture. Yeah, Mr. Parme, inter-district transfer is permissible or?
To that extent, my lord, I need to seek instruction.
Yes, you have any idea?
The Group D employee, as per the
This is, the driver will be group C, I think. Huh?
I'll seek instruction, my lord. Group C or D. Group C, I believe.
We have no longer, we have no group D employees now, is not it? All
Yes,
are-
my lord.
all are
Yes.
group C.
Yes.
Is not it, mister?
Right.
Though he has not raised this contention.
Right.
What medical problem you have?
My lord, this is at page number 14 to 16. My lord, I have a severe spinal injury which has been certified by a team of doctors from the district
Then
hospital.
how you will drive a vehicle?
My lord, I'm taking regular physiotherapy. So within the town, I'm serving as much as possible with the help of regular medical checkup. So in the next place of posting, where in the impugned transfer, there is no such medical facility also. So it will be quite difficult for the petitioner to go back to the where he is currently posted at Bomdila.
Mr. S.K. Jama, counsel for the petitioner, and Mr. L. Parmel, the standing counsel for the Agriculture Department, representing all the respondents. This writ petition has been directed against the order dated 31st May 2023, issued by the Director of Agriculture, Government of Andhra by number said case 11, whereby the petitioner, who is a driver under the establishment of the District Agriculture Officer Bomdila, West Kameng District, Arunachal Pradesh, has been transferred and posted under the establishment of the District Agriculture Officer, Lemni, Pake, Kesang District. Pakistan district. Full stop. Though this writ petition has been filed, challenging the opposite transfer order dated 31st May 2023 on the ground of a health issue of the petitioner. Yet, in view of the fact that the petitioner is a driver under the establishment of the district agriculture officer, West Kamen district, let instruction be taken by the long-standing council for the agriculture department from the department whether inter-district transfer of drivers of a driver is permissible or not. Available Mr. Permit to receive the opposite instruction, let the street petition be listed on 17th August 2023. Also, till then, the status quo is on today with regard to till then, the impugn order dated so and so is shall not be given effect to.
Highly obliged. Highly obliged.
Obviously.
Number 5.
This is item number
5.
5.
Yeah, I was supposed to file an additional affidavit, which I filed, my lord, on 1st of July, my lord. My lord, this matter was listed along with WPC number 223, my lord. So may I humbly pray, my lord, that matter was listed on last Friday, my lord, which has been fixed the 4 weeks now.
Okay, well, listed along with the
My lord,
on the prayer of Mr. Oh, pardon, another council for the petition, read this writ petition along with WPC
223.
223 April 2022.
Number 7.
Please, below. Respondent has not filed their affidavit
Mr.
for the
Upper Limit Council for the petitioner and Mr. I. Learned additional senior government advocate for respondent number 1 and Mr. L. Perman, learned standing counsel for the power department representing respondents 2, 3, and 4. On the prayer of learned state councils listed after 6 weeks for filing of a counter affidavit.
obliged.
Number 8.
Yes.
This red petitioner is working as a casual labor in the department of WRD. And he has been working for almost.
Mr. S. Learned counsel for the petitioner. And Mr. Yes.
We have received our instruction.
You have received instruction? Okay. And Ms. K. Walmo, learned government advocate, representing all the respondents who submits that instruction to file affidavit has been received from the department for which he requests for and is granted 2 weeks time. Listed after 4 weeks.
Number 11.
Yeah,
Yeah.
my lord, in this case, pleadings are over. My lord, in this case, man, some urgency is there. It is regarding my lord supply of medicine kits to the Anganwadi center, post state. Although it is a tender matter.
My lord, there is a stay order also. My lord, this may be disposed of, my lord, this way that way, my lord. Otherwise, it's for supply of medicine kits. Issue is very small. Whether the petitioner's bid can be stated to be a single bid or not. Only interpretation of GFR is required.
Oh, if there is only single bid, nobody else had submitted.
No, they were five.
All are not qualified.
They were technically qualified, but after the inspection of the kit samples, only his sample was qualified. Rest for.
No, you said they were technically qualified.
Yes, my lord. Other documents technically qualified, but for the sample, inspection of the sample, then only his sample was qualified.
A sample has to be inspected.
Yes. Well, this is regarding the supply of this medicine.
Supply.
Along with documents, they have to submit samples of the medicine kit. And that sample.
What is that provision?
My lord, it is, my lord, that provision is in my lord ITB. Instruction will be there. Clause 20, my lord, page 30. Page 30.
30.
Clause 20.
Bidders are required to.
Yes, my lord, submission of samples. The bidders are required to submit one medicine kit containing all medicine on the date of opening of the tender. A director of Women and Child Development Government tender public bids of all those bidders whose samples are rejected by the board of officers or not found conforming to the requisite specifications will be termed as an invalid tender and shall not be processed further. In case sample of item does not conform to the required specification, then the whole tender will be treated as invalid. Sending of samples of
No. Single bid. What is the single bid?
GFR.
GFR.
They are referring to my lord, rule 144 and rule 173.9. 51, page 51 is the rule 144.
Procurement of goods and services. Fundamental principle 144.
Rule 144, my lord.
Fundamental.
My lord, this is not of much relevance. It is talking only about the promotion of competition in public procurement. Maybe it's my lord, rule 173.
170?
73.
73. Transparency.
Yes, 73, my lord, clause Roman 19.
Roman 19.
Yes, page 56.
19.
Page
Yes.
56, my lord.
Yes.
Rejection of all bids is justified when A, effective competition is lacking. B, all bids and proposals are not substantially responsive to the requirement of the procurement documents. C, the bids and public proposals prices are substantially higher than the updated cost estimate or available budget, or none of the technical proposal meets the minimum technical qualification.
This is one GFR, General Financial Rules.
Yes, ma'am, 2007.
It is followed in every tender.
Regarding
Procurement, not in every tender, yeah, other tenders. They
Okay, have you specified in the NIT
NIT,
that GFR will be followed?
No.
Okay, do it on
But
17th.
otherwise, what I'm proposing, my lord, can set aside the impugn order. Subject to, because GFR 20, it clarifies whether this 19 will, how the 19 will be applicable. If my lord,
How the 19 will be applicable?
My lord, as well,
single bid, what
Single
will be
bid,
termed
yeah.
as single bid?
if there is single bill also. In this case, there is no single bill.
Page 57
Page
itself,
57, my lord, Roman 19, Roman 20, my lord.
Roman 20.
One,
Answer, yes, answer to
yes.
this Roman.
lack of competition
Yes, my lord.
shall not be lack of
Determined solely on the
competition
basis
shall
of the
not
number
be
of bidders.
determined solely on the basis of the number of bidders. Even when only one bid is submitted, the process will be considered valid, provided following conditions are met. The procurement was satisfactorily advertised and sufficient time on qualification of the prices. Yes.
My lord, our affidavit basically relies on Roman 19 on the context that there is a lack of competition. We cannot compare the prices. So my lord may set aside, let the bid be open, subject to the prices are being reasonable in comparison to the market value. That discretion can be allowed to the authorities, my lord.
Well, there is, if we come to page 31, my lord. Well,
Because
there-
if their bid is higher or if their bid is too high, then that observation.
Do you accept applicability of the GFR in the instant NIT?
My lord, regarding procurement, my lord. Procurement, my lord, this GFR generally applies.
Okay.
Procurement, supply, regarding to supplies.
Irrespective of it,
My lord,
irrespective of its mention in the NIT,
my
in
lord,
terms of procurement of goods,
yes, ma'am, it should be
this
mentioned.
GFR will apply.
It should be mentioned in NIT, my lord.
Then what he is proposing appears to be reasonable and correct.
But my lord, if, as I come to page
You,
31.
you are challenging what? NIT,
Is
fresh
challenging,
NIT.
fresh NIT for cancellation of the and then earlier NIT and issue
I'm
of
challenging
fresh
this, my lord, decision of tender evaluation committee, technical, which is at page 47.
What is that decision?
My lord, they are decided to go for retender and not to open my financial statement.
Okay.
That is,
So that will be set aside and authorities will be directed to proceed according to Roman 20
23.
of
Yes. Yes.
20 of 20C only.
Hello. See,
C prices are reasonable in comparison to market values.
my lord, that can be, my lord, and my lord, if I come to page 31, my lord, ceiling is there. I will make a, may I
Where?
take your lord to page 31? Page 31, my lord.
31.
Yes.
Yes.
Financial bills should contain following. The prescribed rate of one medicine kit is rupees 1,500. And costing more than the prescribed rate shall not be considered. Ceiling. And my lord, therefore, there is no any chance of my lord prescribing my quoting rate more than 1,500.
What kind of a medicine kit is this?
My lord, that is it. But this is regarding my lord, paracetamol, my lord.
See, medicines are one paracetamol, you will get it for 1 rupee. There will be other paracetamol which will cost 10 rupees. In all medicines.
Bill of my quantity is here.
No, notwithstanding the prescription of this rate, ceiling rate or whatever in the NIT. This is NIT.
And I think,
NID.
my lord, the.
If you accept the application of the GFR, then that clause 20 will apply in addition to this.
Yes, ma'am.
My lord, altogether, my lord, there is 11 in number, my lord.
What 11 number?
My lord,
Medicine.
Medicine, paracetamol, tablet, paracetamol syrup, maybe
No.
benzo, chloromazine.
No. Question is whether you agree to Mr. Ratan's proposal or not. If you agree, we'll dispose of. If not, we'll post it for further consideration next week.
And subject to this rule 173 clause 20.
He's saying,
Yes.
this is on 174,
173.
73.
173.
Okay, ma'am.
Yes, 173, Roman 20,
20 is fine.
and C. Roman 20 C only, I think, Ratan.
Yes, ma'am.
Only C only. And we dispose of in that line.
That can.
Then what is the impute order?
Imperial order is it is 21. Sorry.
Page 47.
Page 47.
You are Geneva.
Geneva.
What is the NID?
21. Page
21.
Yes.
Mr. H. Lambul on the counsel for the petitioner, and Mr. N. Ratan on the AAG for the state respondents. Pursuant to NIET dated 2/3/2023, issued by the Director, Department of Women and Child Development, Government of AP, by number so at page 21, inviting online e-tender in two bid, technical and price bid separately from the intending supplier of repute with past experience in the field and sound financial capability for supply of medicine kits. Supply of 12,450 medicine kits. At the rate of 2 kits per center at an estimated value of rupees 186.75 lakhs. The petitioner, along with others, had submitted its bid, whereafter a summary of the technical bid evaluation was prepared. On which date?
I wrote 6 47. 6/4/2023.
So where are you reading? At
My
page 47.
Page 47, my lord. Meet on, my lord,
Huh?
third line, my lord.
Third line.
Yes, madam. The tender selection committee constituted by such and such status as a meet on 6.
Okay, on 6/4/2023. Where at page 47, huh? Annex says annex of 4 to the writ petition. Wherein? A technical evaluation of the bid submitted by as many as 5 bidders were made. Whereafter it was found that the sample submitted by the petitioner was as per the specification mentioned in the bid document of medicine kit, and other 4 bidders were not qualified due to the shortcomings posted. Therefore, the board recommended for a retender as the single bidder cannot be taken further, stating that as the single bidder cannot be taken further for opening of financial bid as per rule 144 and 173 within bracket Roman 19 GFR -2017. Full stop. The petitioner is aggrieved by the aforesaid recommendation of the board in the meeting held on 6/4/2023. Whereby the retender has been recommended in terms of rule 144 and 173 Roman 19 of GFR 2017. Full stop.
And thereafter, my lord, page 50, my lord. That has been approved, my lord. Approved, my lord. Page
And-
50.
Okay. At page 50.
Yes, ma'am.
Okay. And okay. Full stop. The petition is also agreed by the order dated 26 April 2023, issued by the Secretary, Women and Child Development Department, Government of AP, at page 50 by number so and so, wherever the recommendation of the tender committee for retender has been approved. Also, though counter affidavit has been filed by the. You have taken this stand in the counter affidavit? No.
No.
Okay, though
Only justifying.
counter affidavit has been filed by the state, it's a respondents contesting the case. Mr. Ratan, London Additional Advocate General, however, has submitted that that since provisions of GFR 2017, no? 2017 is applicable in the matter of procurement of goods and services. This this writ petition may be disposed of by setting aside the orders put to challenge herein by the petitioner, and thereafter providing the state respondents to open the financial bid of the petitioner, and if upon evaluation of the financial bid submitted by the petitioner, the requirement of Rule 173, Roman 20, C, within bracket C, is fulfilled. The petitioner's bid may be accepted and worked and
Maybe considered.
maybe considered and work order be awarded. Is not it? You will find whether it is reasonable or no.
My lord, that's why. If,
Okay, maybe consider. Full stop.
on-
Full stop. Rule 173. So 73, Roman
20.
20, clause C reads as under. Lack of competition in Rule 173 within bracket Roman 19 shall not be determined solely on the basis of the number of bidders, full stop. Even when only one bid is submitted, comma, the process may be considered valid provided following conditions are satisfied. A dot dot, B dot dot, and C. Prices are reasonable in comparison to market values. Full stop. The proposal put forward by Mr. Ratan Laman AAG as above has been agreed to by Mr. S. Lampo, London Council, for the petitioner by submitting that. Mr. Lampo has been accepted as according to him. According to him also, the provisions of the GFR 2017 is applicable in the matter of procurement of goods and services. Accordingly, in view of the agreement reached between the London Council for the parties, this writ petition shall stand disposal by setting aside the summary of the technical bid evaluation made on 6/4/2023, recommending retender as per 144 into N173 Roman 19 GFR 2017 within the annex of 4 to the writ petition, and the order dated 26 April 2023 issued by the Secretary, Women, etc. by number so and so at page 50. Approving the recommendation of the board for retender by the technical bid evaluation made on 6/4/2023. I said by setting aside, with a further direction to the respondent authorities. Respondent authorities will do. Our respondent authorities to open the bid of the, so that open the financial bid of the petitioner submitted pursuant to NIET dated 2/3/2023 issued by Director Executive so-and-so by number so-and-so for procurement of 12450 medicine kits. And if on evaluation of the petitioner's financial bid, it is found, and on evaluation of the financial bid of the petitioner, if it is found that the bid, if it is found that the financial bid submitted by the petitioner fulfills the requirements under 173. This is rule 173. Rule 173, Roman 20C of the GFR 2017. The bid submitted by the petitioner may be considered appropriate. Of course, it is ordered accordingly. The petition is disposal with the above direction. Yes.
Here, I'm filing affidavit on behalf of respondent number 3
Ah,
tomorrow, my lord.
okay.
I sent for a letter.
Respondent 3 means who? Health department?
Yes, yes.
Okay.
DMO.
Yes, sure. You are required to file affidavit.
Proceed. No, we have not. We are yet to receive instruction because
Affidavit by other respondents will be required.
And my affidavit one is almost covered up because this land, it's even this is not a disputed land, madam. It's a land belongs to the health department. And the petitioner, they were illegal occupant. And in fact, on their consent and with undertaking, they were allowed to temporarily reside there.
All right. So there is an urgency on your part.
Madam.
When do you want this matter to after?
Madam, after one. Okay, my part is no problem. I will file it tomorrow itself.
we need some more time because we have to send the copies of the petition.
Huh?
We have to send the copies of the petition there. We have received recently on.
No, whether the issue is whether your affidavit will be required. What this Secretary General Administration will do
No, Lordship, there is
in the proceeding under
Deputy Commissioner.
the Public Promises Act?
Deputy Commissioner.
Deputy Commissioner has passed an order in an appeal filed by you.
He is the one who's, the impugn orders are passed by the office of the deputy commissioner.
Deputy Commissioner under the Public Promises Act. Then how he will hear the appeal?
Because there's a provision,
Huh?
there's a provision under the act itself.
You are challenging which order?
Connection number 1, 2, and 3. Page number 24.
24.
This is the notice that was issued by the deputy commissioner.
ESC.
The 2 and annexure 3. 3 impugn orders.
This is a proceeding under Unauthorized Occupants Act. I don't think.
This is exactly not the case that they were allowed to, there's a petitioner, they were allowed to construct a Kata house on undertaking. It's not a fact that they have any right over the land of the department, health department.
Deputy Commissioner acted on the complaint of the
Complaint lodged by the district. Because The particular petitions that we are proposing to consign, even the direct order for district medical, the hospital, district hospital, we are constructing. And this impugn order, this has already been acted upon.
Oh,
It
he,
has already been acted upon. It's
Oh,
carried out.
okay, okay, he has been evicted.
Evicted, and there was, and here we have already constructed, project is being constructed now.
Okay, all right. Administrative, but yeah. But there was a stay over the year.
The stay order, but it is saying that it is practically, it is not implemented because the stay order has been under misconception. Because this has been already been carried out.
All right.
No, even though the demolishment has already taken place, but then the impugned orders were stayed so that they could not be able to proceed further with the construction, because the whole purpose of the petitioners in filing this present petition is so that the land still stays with the petitioner, because they have acted completely arbitrarily and they've not given a fair chance of hearing to the petitioners. Even though the reply was filed, they moved on to pass a final order of eviction against the petitioner.
Okay. You're a government employee.
He was serving as a medical attendant in the Likavali medical unit.
I remember government as for R1 to 3. 1 and 2. Mr. T. Tagulan, Standing Council for Health Department, as for correspondent number 3. On the prayer of the council for the State Council, list 2 weeks time is granted for filing of a counter affidavit. Okay, listed up to 3 weeks.
In the meantime, interim may be continued.
Interim order. No, since he.
No, interim, it is required, Your Honor, because
See,
there is
just-
attempt.
Just a moment. Are you in possession of the land?
We were in possession of
You
the land.
were. You are
And
no
they
longer.
illegally evicted us.
When were you dispossessed?
21st of June, 2020.
21st of June.
I've mentioned it in para 6 of my.
See,
petition.
Jackson, 21st of June, you were dispossessed. Now, this stay order of the eviction order, you were dispossessed pursuant to an eviction order,
Yes,
is not it? But this stay order was passed on 30 June.
yes.
By
After
the,
demolition.
by the time you have already, that order had already been implemented.
Yes.
So we can't continue this order today. If you want any other interim order, different nature of interim order, you may file an interlocutory application justifying that order, that we will consider.
But Your Honor,
But
we're
this
challenging-
simply cannot be stayed.
But we're challenging these orders because we were illegally evicted. And if.
See, let us. What is that order?
At first.
Which
the
has been
Deputy
stayed?
Commissioner- At first, the Deputy Commissioner had issued a notice, that is at annexure number 1, page 20.
No. Which has been stayed? Order which has been stayed? What is that?
Pardon me.
Okay, notice area also. Okay.
Page 24.
Yes, 17 April.
After this order, after this notice was issued, we have filed a reply, which is at annexure number 10.
What is the eviction order?
Eviction order.
Annexure number 3.
26.
26. You read this order. Officer in charge police station is hereby directed to comply with the earlier direction with immediate effect to carry out eviction of unauthorized occupant of medical land by Sri so and so. 31st May. Now this officer in charge came and evicted, they carried out this order on 21st of June. Now, if we stay this, don't you think the public at large who will read this order and who are at Likavali will laugh at the court?
No, Your Honor.
No. What kind of
Because-
order this court has passed when order has already been implemented? If you succeed in the writ petition, we can restore your possession. we can give you the land back with structures. But how this can be stated?
Because Your Honor, it is only on
You
the
ask
basis-
yourself this question, on the next date, we'll deliver it more. 3 weeks, no? And courts, yes, Bhutia, courts do not issue futile writs which cannot be implemented. We'll deliver it. Yes.
Senior Councillor address of Lordship
Hmm.
elaborately yesterday, so I will not repeat.
Hmm.
But my lord, since it has fallen from your lordship that whether my lord a member before he takes oath could be considered to be appointed. So on that part, I will address the lordship.
Hmm.
And my lord, my second line of argument would be, even if assuming my lord, 317 does not apply, then even then my lord,
Hmm.
the grounds on which
Hmm.
the so-called order of recall has been issued is totally arbitrary because my lord, they have succumbed to pressures exerted by non-state actors.
Hmm.
Something my lord, the elected government in a democracy my lord would not have done so. This our pleaded case, how it has happened, I will take your lordship's pleading documents and their reply my lord, where they have admitted it.
Yes.
Now my lord, I have not been able to lay hands on any judgment directly, wherein my lord this issue regarding whether if a member of a public service commission has not taken oath, whether the protection under 37 will apply or not.
Hmm.
But my lord, I will take analogy from other posts that is described in the, that is there in the constitution, which requires that they are required to take oath before entering office, like MLAs, my lord, and the honorable judge of the honorable high court also.
Hmm.
My lord, there is a decision of the honorable Supreme Court that says,
Hmm.
even if my lord, an MLA, my lord, does not take oath, he does not cease to be an MLA.
Hmm.
My lord, the MLAs are required to take oath under Article 188 of the Constitution of India. As long as my lord, his name is there in a notification under Section 73 of the Representation of People Act, he continues to be an MLA. The only thing he cannot do is he cannot take part in any judicial functions or legislative functions, my lord.
Hmm.
So my humble submission in this case would be, my lord, even if, my lord, here your lordship will see the Constitution does not provide for taking oath as far as the member and chairman of Public Service Commission is concerned. But by way of a regulation, framed under my lord 318 of the Constitution, this has been brought in. My humble submission would be not taking oath would only amount to not being able to discharge his duties as a member of the commission. That would be my humble submission.
A member of the commission.
Yes, not able to discharge his function as a member of the commission.
Hmm.
It would not mean that I am not I cease to be a member of the commission.
Hmm.
That is my humble submission.
Yes.
Your lordship may kindly now under government affidavit, my lord,
Hmm.
they have relied upon they have said a conjoint reading of 3161 and 3162 and proviso B of Article 361 to 3162B makes it clear that even after the governor issues an appointment of order, a person does not automatically become a member of the Public Service Commission.
Yes.
So relying upon 3162, the language used in 3162, this argument is sought to be advanced.
Ah.
You could also make kindly 3162. 316(1), my lord, clearly speaks of appointment as a member of the Public Service Commission.
Yes.
The chairman and other members of the Public Service Commission shall be appointed in the case of the Union Public Service Commission or Joint Commission by the President, in the case of a state commission by the governor of the state. Provided that, we have to go into this. Now, madam, we kindly have two. A member of a Public Service Commission shall hold office for a term of 6 years from a date on which he enters upon office or until he attains, in the case of Union Commission, the age of 65 years, in the case of Joint Commission or a Joint Commission, age of 62 years. From what I understand from.
What is this?
3162
What is this? Enters upon his office?
Enters upon his office, my lord, since my lord, here, my lord, nothing is provided regarding oath. If I read only the constitution, my lord, that would be the day I assume office by submitting my joining report. From that, my term of service will be considered. For the purpose of superannuation, for the purpose of holding office, my lord. Till 62.
From date of taking oath.
Yes, no, date of assuming office. In this case, yes, taking oath.
How you will assume office? Here in this case by oath.
Here by oath. But that does not mean if I don't take oath, my humble submission, I will not be able to discharge my function as a member of the Public Service Commission, but does not mean I cease to be a member of the Public Service Commission. My appointment is already done in terms of 316(1).
Suppose your appointment order is issued on 1st of the month.
Right.
Then there is a delay in oath taking. Oath taking is fixed on 30th of the month.
Right.
In between, if the authorities want to remove you, which procedure they will follow?
317.
317.
Yes.
So that means you are a member of the Public Service Commission.
Yes.
Then,
Oath would only mean.
then your period of 6 years will be computed from the date of appointment or the date of the order of the appointment. It is so.
No, as far as that is concerned, from the date of assuming office.
Okay, all right. Yes.
That is my humble submission. Yes, I was submitting, my lord, I have not been able to lay hands on, my lord, a direct judgment regarding 316 and 317. Whether, my lord, before taking oath, because here it does not provide so, it is only by way of a regulation of 318 when this has come into force. So no direct judgment on this. But my lord will kindly note. Article 188 requires a member of the Legislative Assembly to take oath before entering office. Your lordship may kindly have 188. Article 188.
Member of Legislative Assembly.
Yes.
Yes.
Every member of a Legislative Assembly or the Legislative Council of the state shall, before taking his seat, make and subscribe before the governor or some person appointed in behalf by him an oath or affirmation according to the form set up out for the purpose in the third schedule.
Yes.
My lord knows their elections are declared in terms of section 73 of the RP Act. Now, my lord, situation arose before the Honorable Supreme Court. MLAs were declared elected in terms of section 73, but they had not taken oath, my lord, in terms of 188. Now, one of them, my lord, who did not take oath, became a proposer for election to a member of Rajya Sabha. The Honorable Supreme Court has held what taking oath only pertains to him discharging legislative functions. He does not cease to be an MLA. That is the analogy I'm trying to bring in, my lord, in terms of.
To be a member of Public Service Commission, after the order of appointment is issued, you must receive salary also.
Yes.
You must receive all the privileges granted to a member of the Public Service Commission.
Absolutely, ma'am.
That you will get only after you subscribe to the oath.
Yes, ma'am. But does that mean before I take oath that I can just be removed like that, madam? Under what provision? No, there has to be some provision of law, madam.
That legality of how you have been removed, that is altogether a different aspect. The here is that you will not get the protection of 317 unless you subscribe to the oath.
My lord, in my humble submission, I will, because I do not cease to be a member of the commission just because I don't take oath.
Okay, all right.
My lord, if this, trying to draw this analogy, my lord, I would like to rely upon, my lord, 2018 6 SCC 692.
How many judgments you have? If you have too many, you will have to give a list of the judgments by short compilation you have to give.
I will rely on 3 others I will give.
Huh?
I will rely on 3 only.
Okay, 2. Okay. 2006,
2018 6 SCC 692.
2018, 6 SCC,
692.
619,
92.
692.
92.
Okay.
My lord has seen
Paragraph
paragraphs would be 127 only.
27.
My lord has seen, my lord, the member of legislative assemblies or legislative councils are required to take oath in terms of 188. 699.
Yes.
The legal position having been settled for over 100 years, we see no dire necessity or any necessity at all for overturning the law laid down. In Bhupendranath Basu versus Ranjit Singh Bahadur, a question related to the election of 2 non-official additional members of the Council of the Governor General. It was alleged that 2 electors had not taken the oath of allegiance and therefore the election of the non-official additional members was void. An unsuccessful candidate in the election questioned the validity of the election and sought the recounting of votes after excluding the votes of 2 electors who had not taken oath of allegiance. The Calcutta High Court referred to such and such, which noted that a person is admitted to a public office which requires the oath of allegiance only when that oath is taken. However, the relevant regulation did not address this issue. It was held that for the purpose of performing legislative functions conferred by the regulation, it was a necessary requirement that oath of allegiance is taken. The mere fact of omission to take an oath of allegiance did not ipso facto cause a member to vacate his seat. Additionally, regulations such and such gave discretion to the Governor General to declare a seat as void if the elected person fails to take the oath of allegiance. In the cited case, the Governor General had not exercised such an option. Therefore, the mere fact that 2 elected members did not take the oath of allegiance did not result in their participation in the electoral process as illegal. A somewhat similar situation arose in Pasupati Nath Sukul versus Name Chandra Jain. In this case, a member of a legislative assembly who had not taken oath of office had proposed a candidate for election to the Rajya Sabha. Approving the law laid down in Bhupendranath Basu, this court held that as long as the name of the elected members appear in the notification published under the provisions of Section 73 of the Representatives of People's Act 1951, that a member can take part in all non-legislative activities of an elected member. Reference was made to Article 188 of the Constitution, which provides that every member of a legislative assembly shall, before taking his seat, make and subscribe an oath of affirmation according to the form set out in the purpose of the 3rd schedule of the Constitution of India. Article 188, my lord, has been quoted. I will not bother with that. We are of the view that an elected member who has not taken oath, but whose name appears in a notification published under Section 73 of the Act, can take part in all non-legislative activities of an elected member. The right of voting to an election to the Rajya Sabha can also be exercised by him. In this case, since it is not disputed that the name of the proposer has been included before the date on which he proposed the name of the appellant as a candidate in a notification published under Section 73 of the Act and in the electoral roll maintained under 152 of the Act, it should be held that there is no infirmity in the nomination. In view of the above, it was held that since the name of the proposer appeared in the notification published under Section 73 of the Representative of People Act 1951, there was no infirmity in the nomination of the candidate to the Rajya Sabha. The decision of the Calcutta High Court as well as this court were referred to and relied upon in Kamladari for the state of UP. In this case, a somewhat similar situation as in the present proceedings before us arisen. A no confidence motion was signed and carried against the block pramukh. Challenging this, the submission of block pramukh was that 11 elected members of the Kshetra Panchayat had not subscribed to the oath of office after being elected. Therefore, they were ineligible to participate in the meeting, convened for the no confidence motion and to cast their vote. It was contended that these 2 elected members would not be treated as members of the Kshetra Panchayat, and if their votes are to be disregarded, no confidence motion would fail. The High Court rejected the contention following the decisions mentioned above. The learned counsel for the petitioner sought to make a distinction between the performance of legislative functions and non-legislative functions of elected member of Kshetra Panchayat. It was submitted that the Kshetra Panchayat does not have any legislative functions, and its duties and responsibilities are circumscribed by Chapter 9 of the Constitution. The submission of learned counsel may not be strictly correct, since the Panchayat can be empowered by the state legislature to levy, collect, and appropriate taxes. So, however, without going into this issue, the broad intent of the decision of the High Court, Allahabad High Court, as well as this court, is that if an elected member does not take the oath of office, he or she cannot participate in the proceedings of the Kshetra Panchayat unless there is something contrary to in the statute, which is not the case here. Consequently, there is no prohibition against an elected member from being a signatory to a no confidence motion. It is quite possible that in the absence of a signatory, an elected member might get defeated due to his or her inability to vote, but these are not relevant for our purposes. Now, my lord, these was, my lord, by Justice Lokur. At page 703, my lord will find Honorable Justice Deepak Gupta's judgment. He differed on the Kshetra Panchayat, my lord, issue, but he also held that just because you have not taken oath, you does not cease to become of the member of the legislative assembly. Paragraph 44. The language of Rule 3 indicates that the member must subscribe to oath before he can take part in the sitting of the Panchayat. No doubt the elected member continues to be a member because no disqualification has been provided for not taking oath. But the seminal issue is whether such member can take part in the proceedings of the Panchayat. Difference in this regard has been made. The judgment of this court in Pasupati Nath Sukul and names in the Jain judgment. The my lord, I will not bother Rosi with it. The finding, my lord, Rosi will find at page 50, paragraph 50. When you read both the observations together, it is obvious that a member who is elected to a house does not cease to be a member only because he has not subscribed to the oath, unless there is a specific provision in this regard. So, when drawing this analogy, what I am submitting, my lord, my humble submission. Just because I have not taken oath, I did not cease to be a member of the Public Service Commission. And since I don't cease to be a member of the Public Service Commission, my lord, I am entitled to, I am protected by Article 317 of the Constitution.
Yes.
And my lord, another judgment your lordship knows regarding my lord appointment of honorable High Court judges. In fact, the language used is.
Which one?
Judgment is, my lord, 1992 to SCC 428.
This is for what? What?
This is, my lord, this was a case, my lord, is our higher High Court judgment. Somebody was appointed, my lord. Even warrant was issued by the Honorable President. Or
yes.
Appointment is just. Oath was not, could not be taken because there was a stay order by the Honorable High Court. Somebody challenged before that he was not qualified. It was in that context, my lord, the Honorable Supreme Court interfered, my lord, because he was not qualified to be appointed as a judge of the Honorable High Court. But even there, the Honorable High Court said, these are extraordinary circumstances, that's why we are appearing because he is not qualified to be a judge of the High Court, but normally 217 would apply. In that case, also no oath was taken. And my lord knows, in fact, in the Constitution itself, the language used is, who is appointed to be a judge of the High Court shall take oath. That is the language, my lord. It is 1992 to SCC 428.
Yes.
That's so that your lordship have the facts. Your lordship may kindly have page 46, 436. Paragraph 6.
Yes.
The Prime Minister approved the appointment on September 24, 1991, and the President of India on September 30, 1991. The warrant of appointment was signed by the President on October 15, 1991. A notification appointing Srivastava as Judge Guwahati High Court was issued on October 25, 1991. Such and such a practicing advocate filed the writ petition under Article 226 of the Constitution of India before Guwahati High Court on 23rd, 1991, October 1991, challenging the selection of such and such for appointment as Judge of the Guwahati High Court on the ground that he was not qualified for such appointment. He prayed for issuance of mandamus directing the Union of India and other respondents to recall, rescind or Otherwise, 4B for giving effect to the impugned selection of Srivastava for being appointed as a judge of the Guwahati High Court. The writ petition was listed on the same day for hearing before learned single judge. The learned single judge issued ruled and passed an interim order in the following terms. The stay matter shall be heard on October 28, 1991. Meanwhile, the respondent number 1 in India is restrained from issuing warrant, appointing the respondent number 9 as judge of Guwahati High Court. On October 28, the High Court noticed that the fact that the warrant of appointment of Srivastava had already been received at Guwahati, the petitioner was permitted to amend the writ petition, and the hearing on the interim relief was adjourned to November 6, 1991. A division bench of the High Court heard the matter, the stay matter on November 6. After noticing the points raised by the petitioner, the High Court observed as under. In view of the discussion, it is doubtful if the respondent number 9 possesses qualification as provided under clause 2 of Article 217. Therefore, a bona fide dispute has been raised, therefore showing a prima facie case. The High Court, the interim order is the following words. In the result, it is ordered and directed that warrant of appointment issued by the President of India shall not be given effect to by the concerned respondents until further orders. It is further ordered and directed the respondent number 9, Sri Sasensa, is restrained from making and subscribing his oath of affirmation in terms of Article 219. So that was stated. Despite that matter, if you see my kindly at page 20, paragraph 27 and page 450. It is for the first time in the post-independent era that this court is seized of a situation where it is to perform the painful duty of determining the eligibility of a person who has been appointed a judge of the High Court by the President and who is awaiting to enter upon his office. That is by taking oath. We looked into the official records and permitted learned counsel of parties to examine the same. We are at a loss to understand as to how the biodata of Sasensa escaped the scrutiny to authorities concerned. A cursory look at the biodata would have disclosed that Sasensa was not qualified for appointment as judge of the High Court on the admitted fact, which have been on the official files all the time. Needless to say that the independence, efficiency, and integrity of the judiciary can only be maintained by selecting the best persons in accordance with the procedure provided under the Constitution. These objectives enshrined under the Constitution of India cannot be achieved unless the functionaries accountable for making appointments act with meticulous care and utmost responsibility. Mr. Sasensa vehemently argued that in case we come to the conclusion as we have, that on the basis of the biodata taken into consideration by the constitutional authorities, Sasensa is not qualified for appointment as judge of the High Court, then his appointment be passed on the ground that there has been violation of Article 2172 of the Constitution, and there was total lack of application of mind on the part of authorities responsible for making that appointment. We can adopt this course, but after hearing Sasensa, we refrain from doing so and intend going into further material placed on record by Sasensa to show that, notwithstanding his biodata before the authorities is qualified to be appointed to be a judge of the High Court. We are fully aware of the delicacy and sensitivity of the matter and the stage at which the matter has been brought before us for judicial scrutiny. I am relying on this.
Which one?
Next paragraph that I am reading. We make it clear that ordinarily the domain in such matters lies wholly with the constitutional authorities mentioned in Article 217 of the Constitution of India. But in exceptional circumstances like present, where the incumbent is considered for appointment as judge of the High Court does not fulfill qualification, it becomes a bounden duty to see that no person ineligible or unqualified is appointed the high constitutional and august office of judge of the High Court. Here was a case, my lord, this person was not qualified. But the Honorable Supreme Court has said it is under this circumstance we are interfering, but otherwise it ordinarily under 2172. Even he did not take oath.
Where
We
is
make
this
it
said?
clear, madam. We make it clear. Paragraph 28. 11 line from bottom. It starts just after scrutiny, we make it clear.
What is 217? 217 is appointment.
Removal of the judge of the Honorable High Court. Two. No. 217B. Appointment also, my lord. Removal is also here. B. We provide for judge to be removed from his office by the President in the manner provided in clause 4 of Article 124 for a removal by judge of the Supreme Court. It's the same procedure that will have to be followed. Here was a case, my lord, the person was not qualified, so repetition was found, it was interfered. But even then, Honorable Supreme Court has said, ordinarily, if it was not these circumstances, my lord, after warrant is issued, 217 has to be applied. Here also, my lord, oath was not taken to the state by the Honorable High Court itself.
What was the state?
The taking of oath also.
That was by the High Court.
Yes. That is it.
The Supreme Court affirmed it.
Yes, it was interfered because he was not qualified. I am only for the purpose, or ordinarily 217 has to be followed. It is an exceptional circumstance, that is why we have interfered. But ordinarily it is for the authorities, constitutional authorities. It is for that purpose I am relying on this. This was interfered with because this person did not have the qualification matter to be appointed as judge of the High Court. Ultimately, repetition was allowed, he was not qualified.
Constitution of India. Oh, yeah.
217, my lord. Every judge of the High Court shall be appointed by the President by warrant under his hand and seal, and shall hold office in the case of an additional or acting judge as provided in Article 20 in the case until he attains the age of 62. A judge may by writing under his hand address to the President resign his office. B. A judge may be removed from his office by the President in the manner provided in clause 4 of Article 124 for removal of a judge of the Supreme Court. The same procedure has to be followed by.
Yes.
So while relying upon these two judgments, what I am humbly submitting is just because I have not taken oath, I do not cease to be a member of the Public Service Commission. Taking oath only enables me to discharge my function as a member of the commission. And since I don't cease to be a member of the commission, my lord, 317 will apply in full vigor, my lord. This is a humble submission.
Before he had taken oath,
Ma'am.
could he have been proceeded for removal under 217?
That is what I understand from
Let,
paragraph 28.
let us see 217 for removal in the manner provided under Article 124. Let us see 124. What is the procedure prescribed?
124(4).
Yes.
A judge of the Supreme Court shall not be removed from his office except by an order of President passed after an address by each House of Parliament, supported by a majority of total membership of that House, and by a majority of not less than 2/3 of the member of the present House present and voting, has been presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity.
What is this proved misbehavior or incapacity relates to? This proved misbehavior while he was a judge, is not it? Now, if your argument is not to be if your contention is to be accepted, now by resorting to 217,
Yes, ma'am.
misbehavior has to be proved while he was holding an office.
Misbehavior, this does not say so, madam.
So what is this proved misbehavior?
Misbehavior at any point of time, madam, even before assuming office. Incapacity also. Nowhere it is written, madam. Only.
What is misbehavior? What is misbehavior?
My lord,
If you
I
walking on the street,
almost, my lord, one, my lord. At two, my lord, I will bring a judgment, my lord. To reply to lordship's.
walking on the street, if you don't talk in appropriate manner to a person you meet, and you talk rude in a very rude manner, that is also misbehavior.
Maybe, my lord, you see.
It can't be like that. Misbehavior must relate to office you are holding. Unless you enter office.
But, my lord, I have relied upon two judgments, my lord. Your lordship will consider that. 2018 is clear, my lord. 2018 is clear. 2018 judgment, my lord, has seen MLAs are required to take oath before discharging their functions. It is provided in the Constitution itself. Even in the Honorable Supreme Court, they don't cease to be a member of the.
How many times we misbehave in our day-to-day life? You also misbehave, he also misbehave. It can't be that misbehavior. It has to be relatable to the office. So unless we enter office, how is the proof?
I made my submission, and I relied on this for your lordship. And regarding the
Supreme Court at that point of time was perhaps faced with this kind of situation for the first time. They themselves have said so. So delicate, some observation here and there, but it can't be.
It is, my lord, that observation is there, my lord, I have placed reliance.
All right.
And regarding that the query, my lord, I will reply at two, my lord, or I will take your lordship to the facts also.
Yes. No, we still have 5 minutes.
No, there's a judgment of Lord just on I will bring that. So this is my humble submission, my lord.
Yes.
I should cease to be a member just because I did not take oath.
Yes.
Because Constitution itself provides for in respect of the member of legislative assemblies and legislative councils. So drawing the analogy from that case, my lord, my humble submission is that I don't cease to be a member of the Public Service Commission just because I didn't take oath. Now, my lord, even if assuming, my lord, your lordship holds
Yes.
that I am not entitled to protection under 317. Then also, my lord, the impugn actions has to be tested on the principles laid on Article 14, my lord. There has to be some reason, plausible reason, my lord, why this action has been taken, my lord.
Yes.
Advertisement and all, I will not.
Oh, sorry.
I will
Yes.
not bore your lordships with. Your lordship at page 77
77 of.
of the writ petition.
Yes. Annexure 8.
In Lecture 8.
Yes.
This is the minutes of the screening committee meeting. Your lordship will find there are as many as 18 members in respect of the post of chairman of APPSC. 18 applicants. And there were as many as 58 applicants in respect of members at page 78. Paragraph 3 onwards, I read. The screening committee carefully examined the constitutional provisions, the biodata, as well as work experience of all 18 applicants for the post of chairman APPSC and 58 applicants for the post of member APPSC, and considered the eligibility to the post and responsibilities they have to perform as chairman and member of APPSC. The Article 316 of the Constitution reads as follows. I'm skipping it. 5. The committee, after detailed deliberations, after taking into consideration all documents placed on record, biodata of the applicants, age, length of service in case of government servants, qualifications, relevant exposure, details of awards and recognitions, this is not placed before the government for a decision. In respect of chairman, there was only one recommendation. Lieutenant General Santananda.
There appears to be no any parameters, isn't it? No guidelines for selection.
Guidelines in the state, I don't think they have. But my lord, 2013 judgment also says, even if there is no guidelines, this is a requirement that you have to follow. Now, there is nobody's before lordship saying these parameters were not followed.
Yes.
In respect of members 5, including the petitioner at serial number 5, he is under the social sector. Then consequent to this at page 80, this is the approval of the cabinet. After detailed deliberations, the cabinet considered a proposal of administrative department regarding filling up the 1 vacant post of chairman and 3 vacant posts of members of Arunachal Pradesh Public Service Commission. After detailed deliberations, the cabinet approved the following names for placing before the Honorable Governor for their appointments in the Arunachal Pradesh Public Service Commission. The cabinet applied their mind, deliberated, then they accepted this. 1 and 3. Then, my lord, at page 81.
Not all were accepted.
Not all were accepted. 2 were not accepted.
How many was recommended? 5.
In respect of members, 5.
For members.
The one at serial number 1 was not accepted and serial number 3 was not accepted.
Okay. 3 of you were accepted.
Yes.
3 members and the chairman
One
was
chair.
accepted.
Yes.
Government has the option of doing that.
I think at that point of time, only 3 vacancies were there. 1 was still in the post.
Advertisement fee.
Okay.
Yeah, advertisement also were 3.
Then why recommended 5?
They probably wanted the selection committee, or screening committee as it is called. They probably wanted to give some options, additional options to the authorities. That these are the ones we find suitable, and you.
From here you pick up. Selection after selection, you are sitting over the selections made.
But in these, there are many statutory selections also, where the principle that is followed is a panel is recommended. Recommendation itself, the statute itself, like for example, the other case that was there yesterday.
Here it is not even the panel. You see vacancies 3, as per members it comes on 3. You recommend 3 and you give in the panel you may keep 2. It's not even like this. You in a
What in a sense they are saying?
seriatim you have recommended 5. And this the person who at serial number 1 has not been accepted.
Because this is
Who-
not an
who-
order of merit.
How do you say so?
It would have otherwise, the selection committee would have said so. That this is an order of preference or this is an order of merit.
But there is no occasion to.
Ultimately, your lordship,
It is all the more necessary that you should have a guideline.
ideally, yes.
Hmm.
Ideally, yes.
Okay. We'll come back at 2.
Inform you that the Honorable Governor of Arunachal Pradesh has consented.
So
to
these
this-
facts are common.
Yes. What I am submitting, my lord, is cabinet accepted. Appointment order issued. They call us for swearing in ceremony on
17th February.
17th February.
Yes.
I am showing this document for the purpose because the state is arguing that since swearing was not done, so no provision Article 317. It is not a case that it is we voluntarily did not take oath. Circumstances were created by persons with vested interest. It was a duty of the government to ensure that the rule of law prevails. They wanted us on a particular date for the swearing in ceremony to take place. My lord, we have made categorical statements how this has taken place. Your lordship at page 89, 17th of February. In view of the request placed by the Arunachal Indigenous Tribes Forum and Pan Arunachal Joint Steering Committee, the cabinet has decided to call off the swearing in ceremony of the chairman and members of the Arunachal Pradesh Public Service Commission. It was further decided that this matter will be discussed with all community-based organized stakeholders of Arunachal Pradesh. This is on 17th matter. The lordship may kindly have the writ petition matter. We have read it categorically and matter will see how they have responded. Paragraph 90 onwards I will read matter. This is after the appointment order was issued. Paragraph 19, page 20. That the petitioner begs to state that as is the one in this age of social media, the appointment orders of the petitioner and other members and the chairman APPSC went viral on various social media platforms. Various platforms of social media, with thousands having their own opinion about the selections, though the same was made in pursuant to a recommendation of the selection committee and approved by the state cabinet. Thereafter, the Pan Arunachal Joint Steering Committee started veering away from their 13-point demand and started demanding that the new chairman APPSC and the newly appointed members should not take oath on 17/2/2023. The aforementioned demands by the APPSC was widely circulated in the local dailies. They have responded to
These facts have not been denied. They have not denied.
They have not denied. This is for the purpose of showing, my lord. After all, my lord, any impugn action there has to be some plausible reasons discernible from the impugn actions, my lord. What I am trying to show is, it is at the behest of my lord persons who have created a law and order situation, my lord. These impugn actions were taken, my lord. So this was not denied, my lord. 20 also.
Yes.
Then your lordship. Paragraph 22.
Yes.
That on the morning of 17/2/2023, the law and order situation in the whole of capital complex erupted with thousands blocking the road leading to Raj Bhavan and fighting of pitched battle with the security forces and large-scale destruction of public properties by the agitators. That seeing the large-scale law and order disturbance, the cabinet held an emergency meeting and decided to follow the swearing in ceremony of chairman members by succumbing to illegal demand of the agitators. These were categorical case. 22 and 23, no comments.
No, they have said that in the affidavit, it was there was a meeting by this organization.
What I am showing
As
is
well
there
as-
was
all
a
is,
law and order situation created, my lord.
all
I am
stakeholders.
going beyond that, man.
By whom?
By the agitators, by the members of the PHSC and others.
That they will create.
Yes,
The government is not created.
government has not created.
Yes.
They have created. So on the basis of the will the appointment can be recalled, my lord? Would not that be an arbitrary exercise of power, my lord?
All right.
They have appointed.
Hmm.
They call us for swearing in ceremony.
Hmm.
These people does not allow us, and because of that, you do this. Paragraph 24, man.
Yes.
That consequent to the decision of the cabinet to call off the swearing in ceremony of the chairman and members of the APPSC, which was the primary demand of the agitation being carried out on 17 to 2023, the agitators became even more emboldened and continued with the agitation. Consequently, the chief minister made a public appeal to defuse the situation. Accordingly, on the next day, that is 18 to 2023, while continuing with the agitation, a meeting was held in the conference hall of chief minister with the representative of the PHSC. The meeting was attended by such and such, and few members of such and such, about whom it is not known in what capacity they were present. That to the knowledge of the petitioner, the meeting went on for around 8 hours, and the government, in order to assuage the situation, considering the visit of the Honorable President of India, who was to grace the occasion of the Statehood Day on 2023, succumbed and gave into the pressure exerted by the agitator in what is an example of utter capitulation of a democratically elected government who has sworn on the constitution to govern by the rule of law and agreed to the 13-point demands mentioned here and above. Additionally, demand for cancellation of the appointment of the chairman members of the APPSC was agreed upon, and same was to be placed before the state cabinet for its approval. My lord, will see how they have dealt with it. 24 and 25, no comments.
Even this is admitted, all admitted. They are saying that yes.
Yes, they become emboldened. They did this. That is why they did that.
Hmm.
And now you also will see how it came about. Page 90.
Page
90.
yes.
This is the minutes of the meeting
Hmm.
held in the CM conference hall on 18th of February 2023 with PHSC, other representatives, the 13-point demand made by the aspirants.
Who all were there in the meeting?
My lord will see. Your lordship had a query, who are the stakeholders? The government said they are stakeholders. My lord will kindly have page 93 first, madam. The 13, we were not in the 13-point demand.
Yes.
A further decisions were taken, 93, my lord.
93.
Yes.
Yes.
Further, the decisions were taken after 13.
Yes.
The demand for cancellation of order, the present chairman of the AP Public Service Commission was agreed. The same will be taken to cabinet for approval. A fresh search committee will be constituted. A column for declaration of properties of all applicants will be added in the application form.
Hmm.
That is how this decision came to be taken.
Hmm.
My lord will see who the stakeholders are. Who has signed this first? Your lordship will see. The Secretary AR, President Ansu, Chairman PHSC, one person, and another member PHSC. And at page 94 are the so-called stakeholders. The Honorable Minister Home, Minister Sports and Youth Affairs, one MLA, President Ansu, General Secretary Ansu, one activist, so-called activist, my lord. That's number 6. Number 7 is the chairman of Pen Order Joint Steering Committee. Arunachal Nari Shakti. Arunachal Nari Shakti, Arunachal Nari Shakti. The Chief Secretary, Commissioner to HCM. There are other people, then we don't know who they are. These are the stakeholders.
Okay.
Our categorical case is by succumbing to the agitation, my lord, they have taken this. Now this issue was raised in the floor of the House. Page 96.
Yes.
We will obtain this to RTI.
Yeah.
Page 98. This is in reply to a question by a member of the Legislative Assembly, Sri Navam Tuki, by the Chief Minister. This is in Hindi, my lord. Shall I read this or the English version?
Hindi.
This is in Hindi.
Where it is Hindi?
Page 98.
98.
Yes.
What is that? Have you given the English translation?
Yes, I have.
Relevant?
Yes, my lord.
Yes. Which?
It is the statement of the chief minister on the floor of the house, how the impugn actions were taken, my lord.
All right. Do you read the English version?
Yes, ma'am. Page 100.
Yes.
Honorable Speaker, sir, the Honorable Chief Minister has answered the question number such and such. However, through you, I want to ask a supplementary question regarding the present status of appointment of chairman and members of the Arunachal Pradesh Public Service Commission, whether they are functional or not functional, or whether they have been removed. Speaker, Honorable Chief Minister, there is a reply by Chief Minister. Honorable Speaker, sir, as regard to the supplementary question of question number 40, which has been asked by the honorable members such and such in the floor of the house regarding the status of the selection of chairman and member of the Public Service Commission, the government had appointed the chairman and members already. However, there has been protest and aspirants by submitting a memorandum wanted that there should be a constitution of new selection committee and there should be a new selection process for appointment of chairman and members. Anyway, considering the popular demand, the appointments already made after taking the view of learned such and such, we have cancelled their appointment because those appointments were made, but no swearing in had taken place. But it is on the basis of agitations and popular demand. That is in the reply.
What is Senior Advocate General?
It should have been Senior Additional Advocate General.
Okay. Yes.
So this is the reason.
Public demand, popular public demand, and the view of the Senior Additional Advocate General. Okay.
Then, my lord, ultimately, this decision, cabinet decision at page 101, proposal of recall for appointment orders in respect of such and such. After detailed deliberations, the cabinet approved a proposal for recall of appointment orders in respect of selections made of chairman members of the Public Service Commission in public interest. This does not show any reason, ma'am. Page 102 is the notification.
Okay.
Now, my humble submission is, ma'am, the government, it is not the case of the government that there was something wrong in the selection process. It is not their case that the appointments were not validly done and there was some irregularities in the selection process. It is not their case that they did not want it, that we take the oath of affirmation and start functioning as members because they invited us. But it is because there was some agitation took place. They wanted something, they succumbed to it, and that is why this impugn order has been passed. In my humble submission, your lordship may hold that 217 may not apply, but how will they come out from this? Is there any plausible reason discernible from this, my lord, for recalling an appointment validly made? And if that is not discernible, my lord, it will be an arbitrary action, my lord, hit by the vice of Article 14, my lord. And once your lordship holds there is no discernible reason, your lordship will interfere, my lord. They have said public interest and stakeholders. Who are these stakeholders? Who do they represent? In a democracy, somebody may have view. Does it mean, my lord, as government have constituted a committee? A search committee was there. They have scrutinized the application. They have made the recommendations. You yourself have made the appointment order. Invited us for oath-taking ceremony. And because of this, in the affidavit, my lord, opposition, they have accepted everything, my lord. It is the reason. And my lord has seen the minutes of the meeting.
Yes.
So, my lord, once your lordship holds, there is no plausible reason discernible from the impugn actions of my lord to be hit by the vice of arbitrariness, thereby, my lord, hitting Article 14. And as such, my lord, liable to be interpreted. My lord, we have shown from the materials on record that there's an arbitrary action. The onus is now, my lord, shifted to the state. They have to show there was some reasons, my lord.
Yes.
I'm relying upon my lord 1991, 1 2 1 1 SCC 212 Sri Lanka Vidyarthi.
That constitutional bench judgment? No, no, this is another one. For what proposition?
Arbitrary action, my lord.
Hmm. Yes,
Paragraph 33 onwards, 33 to 39,
oh,
at page 242.
paragraph
33 to 39,
33 to
39.
39. Public prosecutor.
Yes,
Okay. Yes.
paragraph 33.
Yes, 33. Hmm. Yes.
No doubt it is true, as indicated by us earlier, that there is a presumption of validity of state action and the burden is on the person who alleges violation of Article 14 to prove the assertion. However,
Yes.
where no plausible reason or principle is indicated, nor is discernible, and the impugn action therefore appears to be expressly arbitrary, the initial burden to prove the arbitrariness is discharged, shifting onus on the state to justify its action as fair and reasonable. If the state is unable to produce material to justify its action as fair and reasonable, the burden on the person alleging arbitrariness must be held to be discharged. The scope of judicial review is limited as indicated in Dwarkada's Marfatia case to oversee the state action for the purpose of satisfying that it is not vitiated by the vice of arbitrariness and no more. The wisdom of the policy or lack of it, or the desirability of a better alternative is not within the permissible scope of judicial review in such cases. It is not for the courts to recast the policy or to substitute it another which is considered to be more appropriate. Once the attack on the ground of arbitrary is successfully repelled by showing that the act which was done was fair and reasonable in the facts and circumstances of the case. As indicated by such and such, the power of judicial review is limited to the grounds of illegality, irrationality, and procedural impropriety. In the case of arbitrariness, the defect of irrationality is obvious. In our opinion, the wide sweep of Article 14 undoubtedly takes within its fold the impugn circular issued by the state of UP in exercise of executive power, irrespective of the precise nature of the appointment of the government council in the districts of other rights contractual states which the appointees may have. It is for this reason that we base our decision on the ground that independent of any statutory right available to the appointees and assuming for the purpose of this case the rights flow only from the contract or appointment, the impugn circular issued in exercise of power. So the state must satisfy Article 14 of the Constitution, and if it is shown to be arbitrary, it must be struck down. However, we have referred to certain provisions relating to initial appointment, termination, or renewal of tenure to indicate that the action is controlled at least by settled guidelines followed by the state of UP for a long time. This too is relevant for deciding the question of arbitrariness alleged in the present case. It is now well settled that every action in order to survive must not be susceptible to the vice of arbitrariness, which is the crux of Article 14 of the Constitution and basic to the rule of law. The system which governs us, the arbitrariness is the very negation of the rule of law. Satisfaction of this basic test in every state action is a sine qua non to its validity, and in this respect, the state cannot claim comparison with the private individual even in the field of contract. This distinction between the state and the private individual in the field of contract has to be borne in mind. The meaning and true import of arbitrariness is more easily visualized than precisely stated or defined. The question whether an impugn act is arbitrary or not is ultimately answered in the facts and in the circumstances of a given case. An obvious test to apply is to see whether there are any discernible principle emerging from the impugn act, and if so, does it satisfy the test of reasonableness? Where a mode is prescribed for doing an act, there is no impediment in following the procedure performance of the act otherwise and in a manner which does not disclose any discernible principle which is reasonable may itself attract the vice of arbitrariness. Every state action must be informed by reason, and it follows that an act uninformed by reason is arbitrary. Rule of law contemplates governance by laws and not by humor, whims or caprices of the men to whom the governance
is entrusted for the time being. It is tried to say, be you be ever so high, the laws are above you. This is what men in power must remember always. Almost a quarter century back, this code in such and such indicated the test of arbitrariness and the pitfalls to be avoided in all state actions to prevent it by in a passage as under. In this context, it is important to emphasize that the absence of arbitrary power, the first essential of rule of law upon which the whole constitutional system is based. In a system governed by rule of law, discretion, when conferred upon the executive authorities, must be confined within clearly defined limits. The rule of law from this point of view means that a decision should be made by the application of known principles and rules, and in general, such decisions should be predictable and the citizens should know where he is. It is, if a decision is taken without any principle, without any rule, it is unpredictable, and such a decision is the antithesis of a decision taken in accordance with the rule of law. Law has reached its finest moment stated such and such, when it has freed men from unlimited discretion of some ruler. Where discretion is absolute, man has always suffered. It is in this sense the rule of law may be said to be a sworn enemy of caprice. Discretion, as Lord Mansfield stated, it is the classic terms in the case of such and such, means sound discretion guided by law. It must be governed by rule, not humor. It must not be arbitrary, vague, and fanciful. After Ghani's case, long strides have been taken in several well-known decisions of this court, expanding the scope of judicial review in such matters. It has been emphasized time and again that arbitrariness is anathema of state action in every sphere and wherever the vice precoles, this court would be impeded by, not impeded by technicalities to trace it and strike it down. This is the surest way to ensure the majesty of rule of law guaranteed by the Constitution of India. It is therefore obvious that irrespective of the nature of appointment of such and such, in a such and such, in a security of such and such, must withstand the attack of arbitrariness and be supported as an informed decision which is reasonable. Now, and this again regarding my lord, shifting of the onus.
Yes.
So now my lord has seen on what basis the impugn actions were taken, how the order of recall came to be issued. Just by filing an affidavit saying something would not mean that this was an informed decision. There is no material placed on record to show that except for the decision taken in the minutes of meeting dated 18/2/2023, there were other factors that were considered by the government, my lord, in recalling the order, my lord. The minutes clearly says it will be placed before the cabinet and thereafter it will be recalled. This is exactly what has happened. My lord, protection of his citizens and to, my lord, see to it that the rule of law prevails. And there is a, my lord, no breakdown law in order. It is not my duty, it is the state's duty. I was supposed to come to the governor's house on 17th. There was an agitation created by some persons. It is not my fault. So now how can you could not perform your duty. Now how can you now say that no, oath was not taken? That is why you can issue this recall order. As I was submitting earlier, my lord, even if your lordship holds that the protection under 217 is not available, my lord, since oath was not taken, I have made submission on that. Then also, my lord, the state will have to pass this test of Article 14, my lord. How do they, my lord, overcome this? Can this be a reason, my lord, for recalling an order? Because it is not their case that the selection process, there was something bad in the selection process, anything like that. Only on the basis of the minutes of the meeting. Because there is no material placed on before lordship to show it was nothing else. Just that. Others, my lord, judgment I will keep. Arbitrary is all. In the duty of the state to my lord. Maintain law and order. It is not my duty, it is their duty.
Other decision means
Regarding my lord, it is the duty of the state to maintain law and order.
maintain law and order.
Yes. And my lord, once a decision, my lord.
Then if the state fails, then what happens?
My lord.
If the state fails to maintain the law and order, what happens?
What happens, I am not sure about it, but it is their duty, my lord. If they
For that, no
if they
decision.
fail, my lord, it will go to NRT, my lord.
For that, no decision is required. It is.
I am just pointing out, my lord.
Uh-huh.
It is their duty. It is my humble submission. It was their duty. It is not my duty, my lord. I cannot be, my lord, going through
You
my lord,
mean-
thousands of people, my lord.
Or you mean to say
Yes.
that,
We were ready to come on 17th.
okay.
So my lord, the decision was solely based on the minutes of the meeting. So that is an wholly arbitrary action, my lord.
Hmm.
So my lord, this cannot stand the test of Article 14 being arbitrary, and my lord will, my lord, intervene on that.
Can the appointment be recalled for any reason that is justified? That is, for any justified reason?
In my humble understanding, no, there is no provision in the constitution. The appointment is made in the terms of the constitution,
Suppose.
and any removal will have to be in
No,
terms of the
no,
constitution.
no. Suppose we hold that 317 will apply.
Right.
Then in that case, the removal will have to be in terms of 317.
Right.
But in case we hold that you are not yet a member of the PSC, so this 317 will not come into effect.
Right.
In your case, then can they recall the appointment of a member before they have assumed office, meaning thereby oath is taken for any reason which may be held to be justified one? For the reasons bona fide?
No,
No,
but
not in this manner.
not in my
Can you comprehend any situation
no, man.
which may be justified?
No, man. In my humble, not in my understanding. Will not.
Suppose during the scrutiny, during the evaluation of your candidature, certain things escape the notice of the screening committee.
Right.
Because you did not disclose it, or they failed to gather those informations. And you have been found to be of a person with criminal background and antecedents belonging to an organization which is unlawful. Can they not recall your appointment order on these grounds?
In my humble understanding, no. Once an appointment has been made, then my
317 has to be applied. Yes. Any other arguments?
That's all, my lord, the sum and substance, that's it, what subject.
All right. Then what is your answer to the questions which the court had asked Mr. Mazumdar yesterday?
Regarding my lord, whether these parameters laid out in, my lord, in my humble understanding, my lord. You can continue. If some materials were before your lordships, showing that, my lord, that requirement, what is the functions are there in Article 320, my lord. This is duties they are supposed to discharge. So it is in the scrutiny has to be done in terms of whether they can function, discharge this function. If somebody was before your lordship saying these parameters were not considered, then your lordship could have, my lord. But because here it is nobody's case.
No,
This is not even the state's case.
that is precisely the question which the court had asked Mr. Mazumdar. This is not a case.
Yes.
That's not an issue here.
In my humble understanding, if somebody was.
Nobody has challenged your appointment.
Yes.
Nor it is the case with the government.
Yes.
But during the course of hearing and the materials placed before this court, it has come to the notice of this court that there is absolutely no guidelines for selection of a member of the PSC. In the advertisement which you have mentioned, is the qualities to be possessed by the applicants. But whether the applicant possesses those qualities or not, you have to judge on the basis of some yardstick,
Yes.
some guidelines, some parameters. Now, if there is no guidelines, Supreme Court, as per back page 2013, has said there should be guidelines. Is not it? And you are not going to be the last member of the Public Service Commission.
Yes, absolutely.
There have been a lot of, and there will be public service, the members of Public Service Commissions. Now, as and when the seat falls vacant, government will fill up the seat in the manner as it has been done now, without any guidelines.
My lord,
Correct.
I answered.
Now, it is absolutely not in the, this is absolutely not the issue raised in the writ petition requiring determination of this court. But is it not of a public importance that
Would have been, my lord, if there were some materials before lordship to show that there has been no scrutiny by the selection committee.
matter doesn't end there. Now, in the facts of this case, when it has brought to the notice of this court, should this court suo motu in exercise of power 226?
Because there is no
Not
guidance.
that, not take cognizance of the fact, not that take cognizance of the fact that there is absolutely no guidelines, no parameters. Selection is done on what basis, we don't know. So prevent this kind of a wide discretion, unguided discretion. Should this court not, can this court so much to go into on what basis the records of the selection of yours as well as the chairman, etc. And after having perused that, if they have followed some guidelines, it's all right. If there is absolutely no guidelines, can we give some findings on that?
My lord, the lordship is.
Because this is not the issue.
Yes, sir. Your lordship is making his query on the basis of this, my lord, Salil Sublock case, my lord. 2013 one SEC. 5 SEC.
Yes.
Here, my lord.
Yeah, absolutely. Supreme Court has said there has to be some guidelines.
My lord, with great
To-
respect, my lord, that may not be the case. These were two judgments by Honorable Justice A.K. Patnaik and by Justice Madan.
Yes.
If your lordship may have paragraph 45.
What is that judgment?
Judgment is 2013 5 SCC page 1. The judgments were authored separately. Valid.
Yes.
What Honorable Justice Patnaik has said, even if there is no guideline, then you will have to follow the parameters to find out whether a candidate is able to discharge his functions as required in Article 320.
Where is that
Paragraph
paragraph?
45.
Paragraph?
45, madam.
Yes.
I have already held that it is for the governor, who is the appointing authority under Article 316 of the Constitution, to lay down the procedure for appointment of the chairman and members of the Public Service Commission. But this is not to say that in the absence of any procedure laid down by the governor for appointment of chairman and members of the State Public Service Commission under 316 of the Constitution, the state government would have absolute discretion in selecting and appointing any person as chairman of the Public Service Commission, even where a procedure has not been laid down by the governor for appointment, meaning it is not necessary that a guideline has to be laid down. Even if it is not there, what is to be followed, that has been given here. Even where a procedure has not been laid down by the governor for appointment of chairman and members of the Public Service Commission, the state government has to select only persons with integrity and competence for appointment as chairman of the Public Service Commission, because of the discretion vested in the state government under 316 of the Constitution is impliedly limited by the purposes for which the discretion is vested, and the purposes are discernible from the functions of the Public Service Commissions enumerated in Article 320 of the Constitution. Under clause 1 of Article 320 of the Constitution, the State Public Service Commission has duty to conduct examinations for appointments to the services of the state. Under clause 3 of Article 320, the State Public Service Commission has to be consulted by the state government on matters relating to recruitment and appointment to civil services and civil posts in the states, on disciplinary matters affecting a person serving under the government of the state in a civil capacity, on claims by in respect of a person who is serving under the state government to the cost of defending a legal proceeding, on claims for award of pension in respect of issues sustained by a person while serving under the state government, and other matters. In such matters, the State Public Service Commission is expected to act with independence from the state government
and with fairness besides competence and maturity acquired through knowledge, experience of public administration. I therefore hold that even though Article 3616 does not specify the appropriate qualities of the chairman of Public Service Commission, these qualities are amongst implied relevant factors which have to be taken into consideration by the government while determining the competency of the person to be selected and appointed as chairman of the Public Service Commission.
Then come to that.
If you Lordship, before that, my lord, may I have drawn your Lordship's attendance, paragraph 52.
Of this journal, 82,
52. 5,
paragraph 85.
5 to my lord, page 38.
52, yes.
Therefore, I hold that High Court should not normally in exercise of its powers under Article 226 of the Constitution interfere with the discretion of the state government in selecting and appointing the chairman of the State Public Service Commission. But in exceptional case, if it is shown that relevant factors implied from the very nature of the duties entrusted to the Public Service Commission under Article 320 of the Constitution have not been considered by the state government in selecting such that. Now these materials are not before Lordship. Nobody is before Lordship showing that this has not been followed. The presumption, my lord, in my
Can we look into the records to find out that whether relevant factors implied has been taken into consideration?
So long as nobody has agitated this and brought it before Lordship, my lord, your Lordship, I will not say your Lordship cannot, I cannot say. Your Lordship may not. Because it is nobody's case. Now, if your Lordship falls for the records,
Then come to paragraph.
they don't amounting to, my lord, scrutinizing what the selection committee has done. Paragraph 154, my lord.
No, that's what we want to find out. What is the basis for selection? Only the biodata or what they have followed?
That is what I am submitting, but there would have been a factor if there was somebody if your Lordship, or on the pleaded case of the state, my lord, that this is the reason that is why this was recalled. Nobody is before.
At page 67, 154.
Yes. Given the experience in making of such appointments, there is no doubt that until the state legislature enacts an appropriate law, the state of Punjab must step in and take urgent steps to frame a memorandum of procedure and administrative guidelines for selection and appointment of chairperson, so that possibility of arbitrary actions is eliminated.
Yes.
This, my lord, in my humble
Unless
understanding,
law is elected.
but this is not a direction, my lord, to every state in the country, my lord. This is a direction. This is my humble understanding. This is not even a direction, my lord. This was, my lord, observation is on the basis of the facts of the case. Because Justice Pannaik has held, even if there is no guideline, that the only thing I understand from that is guidelines is not mandatory. The court cannot direct that you should have a guideline. But the only thing that is required is you have to scrutinize every application, considering the nature of duties he functions under Article 320 of the Constitution.
Anyway, we'll take, okay.
Yes. That is my humble understanding.
Okay.
As far as the merit of the case is concerned, well, if your Lordship.
But you have not submitted that we cannot go into.
I cannot say that, madam. I am saying your Lordship.
You said that we should not go into it.
Yes.
Because
in
the text of this case. Okay.
Yes. In terms of paragraph 52, the language used is if it is shown the relevant factors implied to the very nature of the duty,
yes, we may
not be considered.
Then we may set aside the selection also.
Yes, if it is
we should not do normally,
yes.
But in a given case, if those
because
relevant factors have not been taken into account by the selection committee,
yes.
we have the power to set aside also.
Yes, because but ultimately fact remains nothing is brought before Lordships. Dwarkanath case also. That observations came because there were materials already on record, but a submission was made.
No, the injustice wherever.
But
you are thinking of your post.
No.
I
am making submission on the basis of the decisions that I can understand by.
Yes.
Dwarkanath also, there was an objection raised that the order issued was under section 33 of the Income Tax Act, which is an administrative order, no writ of certiorari lies. It was in that context that
You and Mazumdar is worried about your respective posts.
no, with great respect.
Just a moment. Mr. Chaudhary and Navo are worried about how to get rid of this case. Huh? But but our thinking is not limited to that.
No, my.
We think for the future also for the entire
Yes,
state.
madam, absolutely, I both done that. But my humble submission is only on the basis of what I understand the proposition law in the Honorable Supreme Court has laid down. My understanding is if something is not brought before a lordships, if you calling for a record and scrutinizing it would my lord be like sitting over my lord the findings of the selection committee, whether that be permissible. That is my humble. On the merits of the case, my lord, if your lordship holds, even if your lordship holds the 317 is not applicable, which I submit is applicable, my lord, then also, my lord, the state will have to pass the test of arbitrary, non-arbitrariness because of the manner in which the state action inclination is taken. That is my humble.
Okay.
No problem. Lordship may excuse me.
My lord, as your lordships must have noted, the facts are on a very narrow compass. But before I take your lordship
Yes.
to those facts, one thing struck me, madam, when my learned friend was making his submissions. If all consequences of agitations are bad, by now the Indian independence would have been struck down by the British courts.
All?
If all consequences of agitations are bad in law, by now at least I think the Indian independence would have been struck down by the courts in England.
Okay.
So that may not be an absolute proposition that all agitations leading to some consequences are expressly bad. Coming back to the relevant facts, there are just a few facts which are relevant. First, your lordship will kindly come to the order of appointment.
Yes.
Which your lordship will find at page 82. The very premise on which the submissions have been advanced by the petitioners is that this appointment, the moment appointment under 316(1) is made, it is an absolute appointment. And it is only under 317 that a member or a chairman can be removed. Before I take your lordship through the constitutional provisions, the lordship will first have a look at the order of appointment.
Yes.
In exercise of powers conferred under clause 1 of article 316 of the constitution, read with clause 4 of Arunachal Pradesh Public Service Commission regulation, your lordship will kindly mark this one. The governor of Arunachal Pradesh is pleased to appoint Miss Rosie Taba as member Arunachal Pradesh Public Service Commission. The pay and allowances of the post shall be governed by clause 6 of the Arunachal Pradesh Public Service Commission regulations 88 as amended from time to time with effect from the date she assumes the charge of the office. My lord, I am laying emphasis on this clause 4 of Arunachal Pradesh Public Service Commission regulation, and this appointment takes effect from the date she assumes the charge of the office. And next paragraph, she shall hold office for a term of 6 years from the date on which she enters upon the office. So this 6 years did not start from 7th of February when this notification was issued. This 6 years starts, the clock will start ticking from the date she enters upon the office. So therefore, the very foundation on which the case has been sought to be developed, in my humble submission, is incorrect.
Yes.
Now, my lord, the first submission on the basis of this notification of appointment is that this not only does the constitution provide so, this order of appointment itself is conditioned, dependent upon firstly entering upon the office, assumption of charge, and entering upon the office. And that entering upon the office, I will place the relevant provisions of the regulation, which has been placed by my learned friend Mr. Mazumdar yesterday. Now, if your lordship will kindly turn to page 89. This is the basis on which the order of recall ultimately was issued. This is the decision of the cabinet on 17th of February. In view of the request placed by the Arunachal Pradesh so-and-so and PAN Arunachal, etc., the cabinet has decided to call off the swearing-in ceremony of the chairman and members of the Arunachal Pradesh Public Service Committee. The first thing they did was they called off the swearing-in ceremony, the oath-taking ceremony.
Yes.
Exactly what was done by our High Court in the case of Srivastava, the judgment placed by my learned friend. What was stayed was the oath-taking ceremony of the person who was elected. This is exactly what the government has done. First, they called off the oath-taking ceremony. Now, the next decision, your lordship will find at page 101. The intervening, my lord, all those agitations and all those things have been placed by my learned friend, Mr. Pangi. Your lordship will come to the decision. This is the next decision that is taken by the cabinet. Agenda item number 1, proposal for recall of appointment orders dated 7/2/23 in respect of selections made for chairman members of Arunachal Pradesh Public Service Commission. Next, decision of the cabinet. After detailed deliberations, the cabinet approved the proposal for recall of appointment orders dated so-and-so in respect of selections made for chairman members of the Arunachal Pradesh Public Service Commission in public interest. And based on this decision, the next page, your lordship will find the order recalling. In public interest, the governor of Arunachal Pradesh is pleased to recall the government notification number so-and-so appointing Ms. Rosie Lava as member of Arunachal Pradesh Public Service Commission with immediate. So, in my respectful submission, my lord, these are the facts that will be necessary to adjudicate upon the issues that fall for consideration before your lordship.
Yes.
Now, my lord, if your lordship will first come to page 51. I'm sorry, my lord. Yes, 51. Now, this is what the petitioner has annexed.
Yes.
This is the regulation, my lord. Regulation of 1988. So the appointment order is in terms of 316 read with 1988, these 88 regulations. Now, originally, your lordship finds at clause 4, page 52.
Yes.
There was no requirement of taking an oath. When the regulations were originally framed in 1988, there was no requirement of taking an oath.
Okay.
This has been brought in by way of an amendment. In fact, there are 2 amendments. If your lordship kindly comes to page 60.
60. Yes.
In exercise of powers conferred by the proviso to Article 318 of the Constitution of India, the governor of Arunachal Pradesh is hereby pleased to make the following rules further to amend the Arunachal Pradesh Public Service Commission regulation. I think there is another.
No, it is there.
There is another. That has not been placed by them.
Insertion.
I'll come to that.
Insertion of clause 4B.
4B, your lordship will kindly note.
Yes.
It is 4B which has been, this is oath of secrecy. 4A, your lordship will not find in the writ petition, your lordship will find 4A in our affidavit. So here, what has been inserted is, in the Arunachal Pradesh Public Service Commission Regulation 1988, after clause 4A, the following shall be inserted. 4B, the governor of Arunachal Pradesh or his nominee shall administer the oath of secrecy to the chairman and the members
before entering upon their office on the following form, the form is. Now, 4A, your lordship will find in our affidavit in opposition. At page 15. I'm sorry, Madam. Page 17.
Yes. Yes.
4A was inserted by this notification dated 8th of July 2015.
Good.
And this is the oath of office. The other one, 4B, is oath of secrecy. 4A is oath of office. Insertion of clause 4A, your lordship will find it in the middle. In the Arunachal Pradesh Public Service Commission Regulations 1988, after clause 4, the following shall be inserted. 4A, the governor of Arunachal Pradesh or his nominee shall administer the oath of office to the chairman and the members before entering upon their office on the following form namely. And both these employ this specific language before entering upon their office. And this is the exact language that has been employed in the order of appointment, making it conditional that for entering into the office, you have to take the oath. Now, my lord, if I may take your lordship to the
Just a moment. 4A.
4A.
4A provides that the governor of Arunachal Pradesh or his nominee shall administer, is not it?
Administer the oath of office.
Oath of office to the chairman before entering upon the office on the following terms.
On the following form, namely, and the oath is reproduced.
Now, what is difference? What is 4B?
4B is secrecy. So earlier,
Oh, it's this.
so earlier, when 4A was inserted, there was only oath of office.
Okay.
So by the subsequent amendment, 4B was inserted. That now it has become oath of office as well as oath of secrecy.
4A and B.
4A is oath of office, 4B is oath of secrecy.
Okay, all right. Yes.
Now, in this context, your lordship will kindly have the constitution.
Yes, 316.
316. The chairman and other members of a public service commission shall be appointed in the case of the union commission or a joint commission by the president, and in the case of a state commission by the governor of the state. So, how to be appointed is 316(1). So that will include the process of selection. How he will enter upon office is 3.2. These are two separate and distinct provisions.
Yes.
A member of a public service commission shall hold office. Your lordship kindly note these three words.
Yes.
Shall hold office for a term of 6 years from the date on which he enters upon his office. So mere appointment does not put him on the seat, does not allow him to enter the office.
Yes.
So therefore, now may I read further, or until he attains in the case of Union Commission the age of 65 years, and in the case of the State Commission or the Joint Commission the age of 62 years, whichever is earlier, provided that a member of a public service commission may, by in writing we are not concerned, here he may resign. Now B, a member of a public service commission may be removed from his office. This office is entered upon under 316(2), not under 316(1). So that is the distinction.
Yes.
Otherwise, the constitution makers would have employed language like his appointment may be terminated. They are not talking about the appointment. The word used in 316(1) is appointment, and the word used in 316(2) is holding of office. The constitution makers were conscious about this distinction, and therefore they did not use words like in subclause B, they did not use words like termination of appointment. A member of a public service commission may be removed from his office in the manner provided in clause 1 of or clause 3 of Article 370. And if your lordship kindly now comes to 317, your lordship will find the exact same language. Subject to the provisions of clause 3 of the chairman or any other member of a public service commission shall only be removed from his office. They could have, the constitution makers very easily could have said, terminated his appointment.
Yes.
So therefore, my lord, the submission that the appointment is absolute and the taking of oaths and entering upon office is a mere formality is, in my humble submission, my lord, it is fundamentally fallacious.
Yes.
Because till you enter upon the office, your clock does not even start ticking for that period of 6 years. Now, in this, besides the submission that I have already advanced, that 316(1) and 316(2) operate in completely distinct and separate fields. That is my first submission with regard to
Yes.
the applicability or otherwise of 370. Now, the second submission, second limb of my submission on this is, if your lordship will kindly come back to again 316 and 370. As I was pointing out, if the arguments advanced by the petitioners are to be accepted, your lordship will have to substitute a few words or replace a few words in 316(2) and 317(1). Just to give an example, a member of a public service commission may be terminated or shall hold office for a term of 6 years from the date on which he enters upon his office. This would have been written differently. Your lordship will have to replace these words by use of the word appointment. The 6 years would have to start ticking from the date of appointment. And your lordship is aware of the settled principles of interpretation. I will place a judgment on that. That when the plain meaning is clear, on a plain reading, the meaning is clear. Your lordships will not add or replace or subtract any words. Similar is the situation in 317(1).
Yes.
This removed from his office used in 317(1) will have to be read something like termination of appointment or something. Appointment may be terminated. Such kind of words will have to replace. And on this proposition, I will just place one judgment. The famous graphing industry. It is 2002, volume 4 SCC 297. Para 10 at page 303.
Yes.
No words or expressions used in any statute can be said to be redundant or superfluous. In matters of interpretation, one should not concentrate too much on one word and pay too little attention to other words. No provision in the statute and no word in any section can be construed in isolation. Every provision and every word must be looked at generally and in the context in which it is used. It is said that every statute is an edict of the legislature.
the elementary principle of interpreting any word while considering a statute is to gather the mens and sententia legis of the legislature. Next sentence is very important. Where the words are clear and there is no obscurity and there is no ambiguity and the intention of the legislature is clearly conveyed, there is no scope for the court to take upon itself the task of amending or altering the statutory provisions. Wherever the language is clear, the intention of the legislature is to be gathered from the language used. While doing so, what has been said in the statute as also what has not been said has to be noted. The construction which requires for its support addition or substitution of words or which results in rejection of words has to be avoided. And this last sentence is of utmost. So in order to accept the submissions that have been made on behalf of the petitioners in this case, your lordships will have to replace those words removed from his office and then entering upon the office, holding of office. All these words have to be replaced or substituted. This is my twofold argument insofar as the applicability of Article 317 is concerned. Now, my lord, the significance of oaths of office.
Interpretation of the statutes and the interpretation of the constitutional provisions are the same.
No, so that I will very candidly accept. The strict rigid principles of interpretation in case of statute, because this is a dynamic document, it changes from time to time. Naturally, those strict rules your lordships will not apply.
Okay.
Now, my lord, this situation with regard to taking of oaths had come up before 3 different high courts at 3 different points of time, almost similar points of time, my lord, way back in 1950. There is a judgment of Allahabad High Court. Unfortunately, my lord, there is no direct judgment. Learned friend Mr. Pangini has been very rightly said. Even I did not lay my hands on any judgment of the Supreme Court. But the high courts of Allahabad, Calcutta, and Patna, these 3 high courts had the occasion to deal with the situation of oaths of office in way back in 1950.
Regarding PSC?
No. This is very interesting. Allahabad High Court, which again relies on Calcutta and Patna. Here, an honorable judge was elevated on, if I am not mistaken, 7th of October 1963. Then there was they were administered the oaths. After the oath was administered, it came to the notice of the High Court that in the meantime, the form of the oaths had undergone an amendment. The constitution had been amended and some further words were added in the schedule, changing the form of the oaths. And thereafter, after about 15 days, once it came to the notice, the amended, correct oath was once again administered to the honorable judge. Now a case came up before the said honorable judge, and an issue arose as to, first was the importance of taking oaths, and second aspect was whether not having taken the correct oaths, the amended oaths, the first time the oath was administered, what effect it would have. So both these questions have been answered. We are concerned about the very taking of oath or not taking of. That has been very succinctly, my lord, explained in paragraph 7. If your lordship will extra copy as my lord will kindly have this judgment of Allahabad High Court first.
When the incorrect oath was administered, they were not aware of the amended oath.
Because it had, in the meantime, the presidential assent had come. May I read it out? It will be clear. If your lordship will come straight to the very first paragraph.
64. So 63.
This is
Allahabad.
Allahabad.
Okay.
This criminal revision was listed for hearing before Satish Chandra J, who along with Kapoor and Tripathi JJ was appointed to be an additional judge of this court in the beginning of October 1963. All of the 3 made and subscribed to the oath, following oath in the presence of the Chief Justice
of the court on 7/10/1963. And this was the pre-amended oath that is quoted. I am not troubling your lordship. The Chief Justice purported to act under a letter of authority dated August 25, 1963, addressed to him by the governor of Uttar Pradesh. That letter reads as follows. And according to how the authorization is made by the governor, that is recorded. Now, my lord, next para. Para 3 at the next page. On 18th October 1963, it was discovered that the Constitution's 16th Amendment Act, hereinafter referred to as the Amending Act 1963, had received the assent of the President on 5th October 1963. And by means of Section 5 of that Act, the form of the oaths required to be made by a person appointed to be a judge of a High Court had been slightly amended. Consequently, the same day in the afternoon, the three judges mentioned above made and subscribed oaths in the presence of the Chief Justice in the following amended form. Now the amended oath was administered. Your lordship will kindly skip that portion which is not really relevant. In para 4, there are 3 points noted below. For the first, 3 submissions have been made before us by Sri so-and-so. That the amending act having received the assent of the President on 5th October 1963, all persons who took oaths of office on that date or on subsequent dates could only do so in the amended form, and that inasmuch as Satish Chandra J did it in the original form, he had not made and subscribed the proper oath and consequently had not entered upon his office. So since he had not been administered the correct oath, on that basis itself, it was argued that he had not entered upon his oath. And this position has been answered in para 7.
Yes.
The requirement of making and subscribing oaths by a person appointed to be a High Court judge has existed throughout. etc. It admits of no argument that a person appointed to be a judge of a High Court can only enter upon his office after making and subscribing the oaths required by the law. It is the performance of the oaths that marks the induction into office. It would be noticed that Article 219 of the Constitution uses the words every person appointed to be a judge of the High Court and not every person appointed a judge of the High Court, which would indicate that a person appointed to be a judge becomes one only after oath has been made and subscribed by him. Before that, he is what may be called a judge designate. Your lordship will kindly mark these words. If I may, if your lordship allows me to pause here for a moment. My lord,
member designer. Huh? You want to say the member designer?
Designate. The reason I am saying is just to give you an example. Madam. My learned friend had placed a judgment when an advocate or any other person is elevated as a judge of a High Court. There are 2 things your lordship will notice. Till the oath is administered, the said honorable judge is not addressed as a judge designated. And it is for this reason, even the cause list that is published for that particular day, the first day, the name is blank. Because they cannot, cause list is published one day before, they cannot write justice so and so. Because the oath has not been administered. Now, if I may continue. That article also provides that the oaths should be according to the form set out for that purpose in the 3rd schedule. Now, this is what has been held so far as the requirement of oath. The expression shall, before he enters upon his office, make and subscribe, clearly shows that making and subscribing of oath is a condition precedent to the assumption of office. It is right that the non-performance of a condition precedent cannot be treated to be a mere irregularity. In our judgment, therefore, the provisions of Article 219 of the Constitution are mandatory and at any rate, so far as making the and subscribing of oaths is concerned. We find support for our view from Sunil Kumar versus West Bengal, etc. And these are the 2, my lord, Calcutta High Court and Patna High Court judgments that have been referred to. Now, if your lordship will kindly turn to paragraphs 36 to 38 are also.
Yes.
It is contended that the passage reproduced above is an authority for the proposition that the taking of oath is not of the essence. We are unable to agree with this submission and have no doubt that the effect of the passage is in the reverse. It clearly mentions that making of the oath marks the induction into office. We have ourselves said earlier that the oath confers no new obligations. The obligations to discharge the functions of office diligently, conscientiously, and according to law are not dependent upon the taking or non-taking of oath. They are inherent in the acceptance of office, but merely because the taking of oath casts no new obligations would not justify inference that the oath or its form is dispensable. Now, my lord, if your lordship kindly comes to para 38,
Yes.
then Halsbury's is quoted in para 37, then next para 38.
Yes.
This passage, in our opinion, wholly militates against what the learned Advocate General has contended and supports our view that making and subscribing of oaths according to the prescribed form is a condition precedent to entry upon office, and the failure to perform the same results in vacation of the office if assumed. For the reasons mentioned above, we are clearly of the opinion that the provisions of 219 of the Constitution, even in respect of the oath being taken according to the form prescribed, are mandatory and not merely that. So, this judgment, and in fact, my lord, just to indicate, I am not troubling your lordship in Calcutta and Patna judgment.
Yes.
In the Calcutta High Court judgment, what had come up was when we became a republic at midnight. And the president had taken oaths at 10:15 in the morning. So the question that had arisen before the Calcutta High Court was, could the President of India have taken any action before 10:15 in the morning, before the time of taking of the oath? And it was held that could not happen because the president had not entered upon office.
Paragraph?
But those two are quoted, Malad. I can give the copies. I am not troubling your lordship for the Calcutta and the Bihar. Huh?
No, I had a copy with me.
Oh, Malad.
If you can just mention the paragraph of Calcutta. and-
In fact, may I read it out straight away? Para 24, Malad. I will just trouble your lordship with one sentence.
34.
24.
24. Yes.
Fourth line from top towards the right hand side, your lordship will find the sentence starting the Constitution.
Yes.
The Constitution came into force at midnight on 25th January 1950. The President was not sworn as President until 10:15 a.m. on 26 January 1950. In other words, he was not President until the Constitution came into force. Now, similar is the situation in Bihar. The relevant para is para 61. I am again not troubling your lordship. Similar situation. It pertains to taking of oaths. Now, my lord.
Para 61.
60.
60. What was there?
There also something I have not gone very deeply into the Patna High Court because this was the one I found to be the most relevant. The Allahabad.
Okay.
Now, my lord, there is another Kerala High Court full bench. I to copy the Here, paragraph 8. This was in connection with a minister in Kerala. The allegation against him was that he had incited some terrorism-like activities. And it was the allegation was that he had committed a breach of oath. So the Kerala High Court full bench had the occasion to examine the difference between what is absence of oaths and what is breach of oath. If your lordship will kindly come to para 8. It is in the second page itself.
Yes.
breach of oath is different from absence of oath.
Yes.
Absence of oath prevents entry into office, while breach affects the continuance after a valid entry. If no oath is taken before assumption of office as enjoined by the Constitution, there is no legal title to hold that office, and the writ of quo warranto will naturally go from this court. Similarly, a minister who for any period of 6 consecutive months is not a member of the legislature of the state shall at the expiration of that period cease to be a minister. This is the mandate of Article 164(3) of the Constitution. A person with authority cannot function, and the jurisdiction under Article 226 could be invoked to prevent that usurper in office from function. Now, this was in the context of breach of oath, but in that context, what is meant by absence of oath, that was also dealt with. So, my lord, in my respectful submission, the oaths not having been administered, they had not entered upon office. So, therefore, the rigors of 317 will not come into play at all. Now, my lord, faintly, yesterday when my friend Mr. Mazumdar was making his submission, he faintly indicated, although not with vehemence, that this oath is not prescribed in the Constitution itself. But your lordship has noted, if I may point out once again, if your lordship sees the regulations, it is a regulation framed expressly in exercise of power under 318, Article 318 of the.
Just a moment. This joining of, there is joining rules in the service, in the case of ordinary, just a moment, or in the case of ordinary, this other government employees, there is joining rules. Joining rules is a condition of service. Joining is a condition of the service. I had asked this to Mazumdar yesterday. Because you are given an appointment, you will have to join. Thereafter, you become a member of that service, and you will be governed by a host of rules, service rules. There are incident of rules, conditions of service, etc. Now, the joining is a condition of service. Huh?
I will have to see that.
Okay. Mazumdar, I don't remember Mazumdar had answered this or not yesterday.
Answer is, I was about to come to that.
I had asked him this. Yes, okay. Yes.
Just so, by coincidence, for the other case, to make a comparison with the rules and acts, I was carrying the Assam PWD service rule. Your lordship kindly have a look at that. Exactly what has fallen from your lordship. Your lordship is aware, once a substantive appointment is made, only by exercising powers under 311, one can be dismissed or removed from service. But if your lordship will kindly come to rule 19 of these rules, it is very much a condition of service. That is why all service rules, appropriately framed, incorporates provisions pertaining to joining.
Yes.
The reason is this.
Yes.
A person shall join within 15 days from the date of receipt of the order of appointment or for promotion, failing which the appointment shall be cancelled unless the appointing authority extends the period, which shall not in all exceed 3 months. So, otherwise 311 is required to be followed. But if there is some problem in joining, the appointment itself can be cancelled. Exactly as the situation in this case.
Yes.
So, but your lordship will find in all appropriately framed service rules, joining forms a part of the conditions of service. Because it is a precondition. It has so many effects.
The CCS rules, yes.
Your lordship will find identical provisions in the CCS rules. So, this is so far as, my lord, their main case, the first argument that the only way to remove them is to follow 370, which in my humble submission I have pointed out that is not the case.
Yes.
Now the other limbo of argument, their argument is that There were agitations. There were public demands made by some groups.
So this is so far,
The reason is
no, so far the argument placed is for the purpose that the petitioner is not yet a member of a PSC, so 317 will not be applicable.
precisely.
Yes.
That is the
Ah.
main argument they had developed. That only way to remove them is treason. Otherwise, they cannot be. Otherwise, let us hypothetically, in fact, a similar example had already fallen from your note when my learned friend was arguing. Assuming the situation, be it any constitutional parliament, even for that matter, an advocate being elevated, let us assume Indian Chowdhury's name is recommended. And warrant comes. But Indian Chowdhury is yet to take oaths. In the intervening period, I commit some criminal offense. Will the writers of impeaching me have to be followed to keep me away from a constitutional position like that honorable judge? So
I can give answer on their behalf. They say yes.
so it will be too much. To even before entering office, if you bring in the writers of such strict procedures of removal, will it not be stretching it a little too far? Can the hands of the authorities be tied to such a thing? Now, coming to the second part of the argument, their entire foundation is that there were agitations, there were some groups who made demands, and the government has succumbed to such things. As I said, my lord, our Majesty's government succumbed to the agitations made by our forefathers and gave us independence. That independence has not been struck down by the British courts till now. Your Lordship, remember the long Assam agitation. What was the consequence thereof? The Assam Accord was signed and Section 6A of the Citizenship Act was inserted. If your Lordship will kindly have a look at the objects and reasons of that Amendment Act, your Lordship will, in the objects and reasons, it is recorded that it is a consequence of agitation. Will Section 6A be struck down only because it was a consequence of agitation? 6A is under challenge before the Supreme Court. That is noted now. If your Lordship kindly sees, this is the Citizenship Amendment Act. And your Lordship will come to the fourth page, madam, in that. That is the statement of objects and reasons. The core of the memorandum of settlement, Assam Accord, relates to the foreigners' issues since the agitation launched by the ASU, all Assam students, arose out of their apprehensions regarding the continuing influx of foreign nationals into Assam and fear about adverse effects upon the political, social, cultural, and economic life of the state. Assam Accord being a political settlement, legislation is required to give effect to the relevant clauses of the Assam Accord relating to the foreigners. So, firstly, it was a result of agitations, and secondly, it was a political settlement, which led to the Parliament making an amendment to the Citizenship Act. Will Section 6A be struck down because it was a result of agitations? Similar matter, your Lordship is aware, again, in Assam, there is a long drawn Boro agreement. Ultimately, the Boro Accord came to be signed, and here that is a act being amended. Here the constitution is being amended. So, Lord, can you see how this constitutional amendment came? In the fourth page, your Lordship will again find the statement of objects and reasons of the Constitutional Amendment Act.
No, do you have a power to recall?
Yeah.
Okay.
That is again, which my learned friend, that is why I did not trouble with your Lordship. Otherwise, the power is
Okay, just 21, section 21.
any notification issued. If I issue, what is the purpose behind the provision in the General Clause? If I issue something, I automatically gain the power to recall or cancel.
Even without reason also.
That is what I am coming to.
Okay.
Alright. The entire ground is, entire arguments have been structured on the premise that because it is a consequence of agitation, therefore it is no reason at all. What I am trying to take your lordship to is that itself is the reason. It is, your lordship will find several documents. My friend Mr. Mazumdar did not place any of those documents. Those documents have been placed by my other friend Mr. Panu. What has he placed? Numerous public demands by various organizations. Your lordship will not find a single public demand in the petition saying that we want these people to continue. So that itself, the materials placed by the petitioner itself is demonstration of the fact that there was an overwhelming public interest, public demand, public, let us put it, a demand put forward by the public at large. That no, you cannot. There is one of the reasons your lordship is noted. My friend had pointed out. One addition has been made in the new advertisement that has been. Earlier, there was no requirement of declaring a property. That is definitely a yardstick to judge a person's integrity. And what does the Constitution say? Integrity. What does the 2013 Punjab judgment say? Integrity is one of the elements. Now, what we have done is twofold. Firstly, we had a meeting with all the stakeholders.
Who?
Various organizations came forward.
You means who?
Constitutional functionaries, one of officers, chief secretary was there.
In other words, the government. Okay.
Then
Government had consulted with all the stakeholders.
I will not say all.
Okay, with
As many who came forward.
okay, with the stakeholders. Now let us. Who are these stakeholders which have been recognized under the Constitution?
That I will not say. Even ASU is not recognized under the Constitution. Parliament has taken note of. In fact, if your lordship will kindly allow me to place the follow
Governor.
Here a terrorist organization has been taken out.
See, as far as we understand, the functioning of the government is like this. Governor will act in terms of the aid and advice given by the Council of Ministers. Now, the Council of Ministers has a cabinet who is collectively responsible. They take a decision. They put forward it to the governor. Every issues, every decisions, because they are accountable. This is our limited understanding of how the function. Now you said that you have consulted the stakeholders. Now apart from this cabinet and the Council of Ministers, who are those stakeholders?
Cabinet is the representative of the people of the state.
Yes, yes.
It represents the whole state.
Cabinet has to cabinet has to function in consultation with the stakeholders.
No. What had happened was we wanted to hear their response. Because ultimately we are
No, just a moment. You wanted to hear whom?
They had some demands.
Who they?
Various organizations. Various people.
No, you name those organizations. I think in state of Arunachal Pradesh there are thousands of organizations. So which organizations you?
That is why I was making a submission to your lordship. Even now, this repetition has been pending for almost 3-4 months. Till now, not a single public demand saying that these two petitioners should be retained. All that has been raised by the petitioners themselves in saying that remove them. Agitations to remove them. But not a single person came forward, even today after 3 months of this pendency. Not a single document is of record to show a reverse thing.
Then you remove them.
Since there
is a growing public demand to remove them, then you will remove them.
No, I'm not saying. We are, your lordship recalls that famous line of Abraham Lincoln. We the people, by the people, for the people, and of the people. That is democracy.
We are a constitutional democracy.
It must
Let
be-
us find out the stakeholders. Yes.
I'll come one by one.
Yeah.
Kindly help for a moment the constitutional assembly regulation. It's volume is book number 5, volume number 11 from the constitutional assembly regulation.
No,
Here,
see,
the
just,
manner in which the constitution has been framed.
just a moment.
What is the
After it was debated, we have got this document. How the government functions, how the government will function. It will be there. If there is some difficulty in understanding this, then we'll go to the debate, etc.
The constitution itself does not say
Yes,
manner in which the constitution was framed. But the reason in which
it has already been framed.
is that
Yes, we are not supposed to look into how, what was the debate when this Indian Penal Code was drafted. We have to understand from the Indian Penal Code.
if
No.
if I
Yes.
have understood with my limited understanding,
Yes,
there are situations where we have to go back to the historical documents.
yes,
Otherwise-
yes. In case there is a difficulty in understanding of the provisions of the constitution, then we will refer to here and there.
One sentence. Here, just one
Now,
sentence.
before that, how the executive has to function? It has already been given to us in a synopsis form. Debate runs into volumes. Is not it? So this is the final product.
I was just trying to point
The
out.
executive governor officer
Even I did not
one-
know the line in this one.
153,
Well,
Article 153, 154. Thereafter, it goes on, then 164.
Yes.
163 is the Council of Ministers.
Yes.
164 other provisions as to the ministers. And then 165 is you. 165 is you, the advocate. See, so that is how, see, all decisions will be taken by the cabinet and governor will issue order. Because cabinet is accountable. Now this, where in the provision that cabinet will listen to the stakeholders? In that will be a governance will be from the state.
No, that is why your lordship allows me to just base it.
Yes,
Ultimately, the elected representatives are representatives of the people of the state. So if we don't listen to the people, who do listen?
all right,
If we don't listen to the people that we represent,
all right. This morning we have done a case where there is a growing demand for erecting of what they call statue of honesty. Why are you not allowing that? You listen to the people.
your lordship,
See, just a moment.
all demands, if we find that there is some substance in the demand, and if we find an overwhelmingly large, your lordship, kindly allow me to base it. I may, as a person, I may,
We will not devote much time on this.
no, I will not trouble that.
We will not devote much time
I
on
will
this.
wrap up in 5 minutes. I
Yeah.
will wrap up just in 5 minutes. I was just, before, we digress.
Now the government of Arunachal Pradesh is functioning with the aid and advice of the stakeholders,
No,
and thereafter they render advice to the governor.
no,
It looks like from your arguments.
no,
If we don't listen to the stakeholders,
no.
Stakeholders-
Completely.
stakeholders have put us to this chair.
Perhaps, that is why, that when we use the Queen's language, we are not able to express ourselves very clearly. What I was trying to say is, as members of the cabinet, we represent the will of the people.
See,
When someone,
just a moment. You have been authorized by the people to run the state
Yes.
by taking a decision. You have to take a decision. What is the question of a referendum kind of a?
no,
think stakeholder, I'll ask that stakeholder, huh? Whose voice is greater, I'll listen to that.
Your lordship is one of the.
Anyway, this is the.
Your lordship is one of the. How do I put it? On that issue.
You have a difficult case, Advocate General, in this, on this count.
Ultimately, your lordship has to decide.
Yes.
Because
Because,
ultimately, your lordship has to decide. What I was trying to say is, it is not that merely because a demand is made, we acted. We debated it in the cabinet.
yes,
That was one of the, maybe one of the initiating points. But ultimately, it was debated. If your lordship kindly comes back to the cabinet decision.
otherwise, judicial power is also, it's judicial power also is also in the nature of a trust we hold for the people. Are you required to consult the people?
No, but your lordship hears them.
Huh?
Your lordship hears them. Does your lordship, when a replication is filed, does your lordship pass an order without hearing the parties? Your lordship hears.
Okay.
Your lordship gives an opinion.
That is the part of the judicial process.
Exactly. It is also because unless there is a consultative process in the whole functioning of the government.
Let us try to find out what you are arguing of consulting a stakeholders from the constitution as well as the rules of executive business which you have made, how you will function. Let us try to find. If you want to find out the provisions of giving hearing to the council representing we'll tell you where are those rules. It is just because there are in the rules, that is the mechanism provided in the dispensation of justice. We hear the counsel for the parties, then we decide. Now, likewise, where are those provisions that the government will have to function in consultation with the stakeholders? This is what the court has been unable to locate.
In fact, that is the reason I want to place the motion.
Yes. Yes.
If your lordship will
Constituent Assembly debates.
your lordship will kindly come to the third page. Just one sentence I wanted to do.
Yes.
Not one sentence, or two sentences I wanted to order to. In the last page of the compilation,
Yes.
your lordship will kindly come to the third line from the top.
Yes.
This constitution, which we are going to present to ourselves, is based on democracy. The world is after democracy, and we are also following the same path. According to Abraham Lincoln, democracy means the government of the people, by the people, for the people. We have framed our constitution according to that principle.
Yes. That's why we have given to ourselves this document.
Yes.
Where we don't find that the stakeholders has to be consulted.
So, there cannot be any provision saying that the stakeholders have to be consulted. What I'm trying to say, I have perhaps not been able to make myself clear. What I'm trying to say here, submit for your lordship's consideration here, is when a cabinet represents the people of the state, and we find that there is an overwhelming dissatisfaction regarding some action that we have taken.
There cannot be any one public opinion. Publics will be divided on any issue. On a issue, 40% of the population, public holds opinion 1, 50% of the population or public holds opinion B, all right, and then yet another remaining person holds yet another. Which one you take? Who is public? Majority. And where is that provision in the constitution? It is once you are elected, it is you alone who have to take a decision. And you are accountable for that, whether you are a legislature or you are a executive. You can't in your day-to-day discharge of your function. For example, in the case of whether the appointment is to recall or not, you have to consult the stakeholders. It takes the opinion of the public. Public opinion is not unanimous. Then which opinion you will follow?
That is why.
Public opinion consultation of the stakeholders is unknown to the Constitution or the elected representatives. It is foreign to the provisions of the Constitution.
Your lordship is absolutely to that extent, but I will not get into that. What I am trying to say.
Otherwise, on every issue, you run to the public. What to do? Give advise us.
Your lordship is completely misunderstood my solution.
Okay.
What I am trying to say is there is a situation of an overwhelmingly large number of people saying that there is something wrong with this election that we have completed. We are not satisfied. And we need the cabinet. So it is not impulsively take a risk. That's why I pointed out the sequence of it. We first, what we did is, let us postpone the taking surrender. The cabinet first took a decision to postpone the taking surrender. Again, analogy can be drawn with the judgment placed by my learned friend. When the said gentleman was elevated, what this High Court did was first take the taking surrender. And thereafter the matter was examined. And similarly, after having deferred to the taking surrender in the cabinet, now discussed. Deliberated upon it. And that is how the final. May I take your lordship back to pages 89 and 91 of the report?
Facts are not in dispute.
No, what I was.
But the consensus issue is this stakeholder business.
No, your lordship will kindly. Your lordship will kindly come to first. First, your lordship will kindly see the matter. That is why each of the documents.
89.
89.
Yes. 89. Yes.
Now this.
In view of the request placed.
In view of the request placed by the Arunachal Indigenous Tribes Forum and Pan Arunachal Joint Steering Committee, the cabinet has decided to.
So you have acceded to the request of these two entities.
Allow me to refer.
Yes.
So what we did was there was an overwhelming demand. Had we on this day itself, have we decided to cancel it?
Just a minute.
Then what we did was now we are actually having look at this.
Read further, read further.
Yes.
It was further
Decided that this matter will be discussed
with all community-based organizations
and stakeholders.
Stakeholders. Where do you find in the functioning of the government the role of a community-based organizations and stakeholders to discuss on policies which you are going to implement, the decisions you have? Where are they? Yes.
Where did the parliament get the power to listen to a terrorist organization and amend the constitution?
Anyway, we proceed. Yes.
So what I was pointing out is here, first we did not take a decision to straight away recall. What we did was
had this cabinet decision been in this form, the cabinet, after due deliberation in the matter, decides to call off the swearing-in ceremony, etc. Then it would have been more appropriate. Somebody is saying something like that, and you are the cabinet has full authority to take decisions because you have been entrusted for taking decision for 5 years. But you have to take decisions on your own by taking relevant factors. These are not extraneous factors.
Your lordship will kindly come.
Yes.
Your lordship will kindly come to 101.
All right.
100. That is not the implementation. The interim decision is not 17th February.
We have read your affidavit, Mr. We have read your affidavit, yes,
Your lordship kindly make a note of the page 89 date.
yes.
It is
Seven,
17th of February.
yes,
And now the impugn decision,
yes. At page 101,
101.
yes.
After detailed deliberation, exactly what has come from your lord. After detailed deliberations, the cabinet approved the proposal to recall for appointment orders so in respect of selections made for chairman so and so in public. Here,
Yes,
I have not been able to express myself perhaps earlier. What I was trying to say is that all those demands made might have triggered an action. The action itself is not based on that. The action is
sorry.
based on detailed deliberation of the cabinet. And it is not a immediate decision. That is why the dates are relevant. If your lordship can see page 89, it is 17th of February. And this decision is of 29th of March. So we deliberated, the government at different levels deliberated, discussed for more than 1 month. And after that, this decision was taken, and as has been rightly pointed out by your lordship, that this decision was a conscious decision of the cabinet after detailed discussion.
Yes,
Because it has been made to look. That is where perhaps I was not able to clearly express myself. This 17th of February, you might say that agitation this, that. But when it came to 29th of March, to actually recall the orders, it was after threadbare discussions by the cabinet. And it was not an impulsive one-day decision taken.
is there a private respondent in this petition?
I don't think so.
No.
I was going through your affidavit. Affidavit in opposition filed by private respondents number 1, 2, and 3.
By mistake, that must be a type of affidavit.
The affidavit filed in the earlier writ petition and in your case, is there a difference? Because
More or
yesterday,
less, almost.
because yesterday we have read the affidavit filed in the earlier case. But when
The grounds are similar.
looking at your affidavit, looking at the counter affidavit filed in your case, it doesn't look like same.
Because in my document, it is in
No, the initial paragraphs.
Because he has actually found that.
Where, just a moment,
There are more facts in his case.
let us just take the affidavit filed in WPC 223 just once by you.
It's from 1 and 4.
Huh?
It is respond number 1, 3, and 4.
Where? In his case?
In our case, 2 to 3.
Yes, in your case, 1, 3, and 4.
1, 3.
Yes.
The
Yes.
stand of the question of law is the same.
Paragraph 8 in the paragraph 8, how the decision was reached.
Yes.
In the earlier case, Mazumdar's case,
Fine.
further the so and so submitted a letter on 3/12/2022, which contained a 13-point memorandum to the government for consideration. The answering deponents humbly beg to state that owing to the unprecedented public demand, the Honorable Chief Minister invited all the stakeholders, including the so and so, for a meeting on 18/2/2023. These two entities are not recognized under the Constitution to discuss the issues raised by the public. In the said meeting, the 13 issues raised by so and so earlier were discussed, and the stakeholders were updated with regard to the steps taken by the government thereon. It was inter alia minuted to recall the appointment orders of chairman members and place the matter before the cabinet. meeting chaired by the chief minister with the stakeholders, not with the cabinet. There it was minuted on the basis of demand, 13-point charter of demand submitted. Then it was minuted to recall the appointment orders of the chairman or members and place the matter before the cabinet. And then on that minute was placed before the cabinet. That is where you have taken the cabinet decision as proposed. We recall. So it's not that the cabinet on its own had discussed independently.
That is why.
So it was on the basis of the.
I cannot improve upon the record. It is on evidence. I will
That's
not
right.
last person to try and improve upon the record.
And this court was also only trying to understand from the learned advocate general that in the functioning of the state government of Arunachal Pradesh, is there any provision under the constitution to consult the stakeholders whenever a decision is required to be taken by the cabinet? Because in the constitution, we have not noticed so far. It was in order to understand if there's anything only this question was there, because in the constitution prescribes, like all other states, you have to take a decision on your own. You have been authorized to take decisions in all matters for 5 years. Not these stakeholders have been authorized. Yes.
I hope, madam, a similar view will be taken in many other cases where the ministers unilaterally decide to send him, MLS send him here, send him transfer him there. That apart. But I'm posing this question to myself. Is there any provision in the constitution which says that I will not listen to the people of this state? Is there any provision in the constitution which provides that I will go against the will of the people?
So
act against the will of the people.
So the argument of the advocate general is, since there is no prohibition in the constitution, we will do anything which is not prohibited.
No. What I'm trying to say is,
Nazir Ahmed, Privy Council.
what I'm trying to say is this.
Anyway, let us proceed. Yes.
Democracy is of the people, by the people, for the people. And when it overwhelming public demand triggers a situation and we take an independent decision, the cabinet, it is not that on 17th of February itself, we simply, the word used by my learned friend is succumb. Had we succumbed, we would have taken the decision on 17th of February itself. We waited. Your lordship kindly neglect no.
So your next contention is the recall of the appointment of the writ petitioners have been made by the cabinet because there is an overwhelming public interest.
No. That is where I am trying to. I have not been able to make myself clear. A situation was triggered by a overwhelming demand.
Of whom? Of whom?
Of the public.
Public means who?
Public, all stakeholders.
Arunachal has how many population? Approximately?
We could not have gone for it.
So who is public?
Public at large.
Public at large. How many percentage of the people of Arunachal Pradesh?
We don't have the data.
Okay, all right.
Only thing I know is in this petition or in the connected petition, there is no data.
Because
even one person opposing.
Democracy, which you are repeatedly referring to, must take into the views of all the populations, not the segment of the populations. Is not it? So that in that context, it is relevant to ask what was the overwhelming demand of what was the percentage of the population who, according to you, had made this demand?
That we don't have to.
All right.
If your lordship asks me this pointed question, even without taking instructions, I can assure your lordship that we don't have the exact percentage of population who was in favor or who was against.
Okay. All right.
The question that I'm posing to myself here is a situation. Let us assume, just to give an example, yesterday a file was endorsed to me by the government. But one section of the advocates have approached the chief minister and said that we need an advocates welfare fund. And the chief minister is considering that request. Is it, posing a question to myself, would that action of the chief minister considering that proposal, request, only because it has come from one section of the advocates? Will it? I'm just asking this question to myself.
That,
The similar situations.
that
We submit representation for various things. And your lordship issues directions saying that consider this representation and take a decision within 3 months.
that situation in the view of this court has no relevance to this case. The view of the court may be wrong, but this is the primary basis view of this court. It has no relevance. A group of advocates going to the chief minister asking for a welfare fund has no relevance to the case.
What I'm saying is, various citizens made representations to the
You have a, see, Mr. Advocate General, you have a difficult case on this point. See,
we can only put in an effort to assist you.
see, earlier your arguments we have noted, it's noted.
Your lordship will note these arguments and if your lordship so deems appropriate, reject it. And just 2 things I will. I won't talk, waste your lordship's time anymore. Just 2 things I would like to place before the lord.
No, we are not, see, we are not cutting short your argument on this issue also. See, just it was the curiosity of this court also. Since you are here taking the advantage of the presence of the Advocate General, then see, stakeholders have been coming up repeatedly, isn't it? Community-based organizations. It was Mr. Advocate, it was taking the advantage of your presence only. That this court was very more than enthusiastic to know if there was any provision in the constitution, so that some legitimacy, something like that. Nothing. And thereby by asking this question, I'm not at all cutting short your arguments. You are free to advance your arguments on this point also. Yes.
I am the last person to make a submission that there is a provision. I was just factually, my lord, you are just make a note of this submission. I cannot improve upon the records as they have. Capital has been filed. All the things are recorded, all the materials are recorded. On 17th of February, we get this demand from various, maybe I would say some organizations. Now, the cabinet takes a decision that we will defer the off-taking ceremony and we will consider this. Next day, a meeting is held with some of the stakeholders. Thereafter, that is 18th of February. From 18th of February till 29th of March, obviously things could not have been idle. There would have been discussions, deliberations of multiple levels. Ultimately, the matter is taken to the, your lordship said, pointed out that the proposal has been approved by the cabinet. The proposal was made on 18th of February. And the cabinet accepted, if that is the proposal, it took deliberated for more than a month, considered it at various levels more than a month. And on 29th of March, your lordship notes, unlike in the 17th February cabinet, where these organizations are mentioned, on 29th of March, there is no reference to any of them. What it says is in public interest. We consider it appropriate to recall the appointment. That is so far as the facts are. Now, my lord, what I was pointing out from the Citizenship Act And similar is the situation, the Lordship can allow me to place this. The Constitution Amendment. This is the if your Lordship can come to the third page thereof.
Yes. There is Assam agitation, something like that.
That is the Citizenship Amendment Act. There is another Constitution Amendment Act that I have given. This is the amendment to the 62.
Okay.
If your Lordship will kindly, if your Lordship will kindly come to the again statement of objects and reasons. Here, my Lord.
Just a moment. Which one? Sixth schedule to the Constitution? This one.
Your Lordship will kindly come to the third page,
Okay.
which has the statement of objects and reasons. I was just pointing out to your Lord, trying to draw your Lordship's attention to this page.
Okay, yes.
Your Lordship can come to the second paragraph. The Borough Act was signed on February 20, 1993, with all Borough Students Union and Borough People's Action Committee, with the objective to provide maximum autonomy to the boroughs within the framework of the Constitution for the social, economic, education, or cultural advancement. In pursuance to Borough Accord, an interim Borough Council so and so was constituted by the Government of Assam by enacting state legislation. Borough groups were of the view that Borough Accord had become unworkable due to non-implementation of the accord in letter and spirit. Based on the tripartite talks, a memorandum of settlement has been signed between the central government, the Government of Assam, and your Lordship will kindly note the third. This was a declared terrorist organization, Borough Liberation Tigers. So, the central government, the Government of Assam, entered into this memorandum, and based on this demand, the Constitution gets amended. So, therefore, what I was trying to draw your Lordship's attention to is when there is overwhelming
Public demand.
It is not that this is for the first time in the history of our country that a decision has been triggered. I'm not saying a decision is based. A decision has been triggered because we cannot draw that assumption because of the time lag from 17th of February to 29th of March. And secondly, in the final cabinet decision, there is no reference to any of these so-called stakeholders or organizations or whatever. So, one cannot say that that is the only reason why we did it. So, therefore, my Lord, based on these, now let us test this situation from another angle. Assuming we say that the cabinet decision which says that it is in public interest. Which says that it is in public interest. One can interpret it to say that it is in the interest of the public at large. Can it be said to be no reason at all? Or is it such an overwhelmingly irrational decision that your Lordships will exercise the extraordinary jurisdiction to interfere with this reform? Ultimately, your Lordship, I will not trouble your Lordships with any of those decisions. Ultimately, the exercise of your Lordship's power under extraordinary powers under Article 226 is also one of the reasons to further public. Therefore, I have looked at from whatever angle. Firstly, they could have perhaps had a case had they been able to bring it within the purview of Article 370. That this is the only manner you could have removed them. But that, as I have demonstrated before your Lordship, that argument completely falls true because they had not entered upon their office. Now, that hurdle having gone, the cabinet takes a decision in public interest that we are going to recall and we are going to issue a fresh advertisement, and this time we are going to check the integrity of the candidates, we will insert a clause that you will have to disclose your form. That is one of the decisions taken. Will that not be what has fallen from the lordship in connection with the guidelines? Will that not be one of the important parameters to test the integrity of a person? If a person has, let us assume a person who is known to have served under the government, barely 10 years of service in the government, and he has amassed a huge amount of wealth and property. That will be a relevant yardstick to judge a person's integrity. It is not merely that. If your lordship sees that advertisement, new advertisement for a moment, mother, if your lordship comes to, if your lordship comes to page 105 of
The repetition. So how have you selected in the instant case?
that my learned friend has already told them to send the report. When my Mr. Mazumdar comes for his reply, that will produce.
Okay.
That instruction also has already been issued. Now, my lord, if you want to kindly compare 105 with the advertisement based on which they were selected and appointed.
105.
105 is the new advertisement which they have challenged. And if your lordship will kindly.
I'm sorry. Yes.
If you have a question to transfer, I mean.
No, earlier advertisement has annexed. Perhaps we have also annexed, I think.
Yes.
Okay. Yes.
If your lordship has both the advertisements together.
Except for the property clause.
Yes.
Okay.
This is a new insertion in the new advertisement. Subclause E, your lordship will find. The applicant shall also submit the declaration of properties in prescribed form placed as annexure B around them. So this is a yardstick that has been incorporated. Because this can be an indication of a person's integrity.
No. If the person declares the property, what will that indicate? See, no, just a minute. Depending on the nature of property, the applicant whole, would you be able to find out the competency, honesty, integrity? This I find it to be absolutely irrelevant. This will have relevance after he joins the office.
No, even for whether.
No, before joining it has no relevance. See, after he joins, after the join, then this will have a relevance. You have to declare. But before joining, what purpose it is? You have to pick up from the applicants. All the applicants will declare their properties. But how will that render you assistance in finding out the level of honesty of the applicant, their competence, integrity? More property, the more competence. No. So it's absolutely irrelevant.
No, I will just indicate.
Yes.
Assuming a person has served as a teacher under the government in some school, and he has amassed a huge amount of wealth, huge amount of profit. That can be an indicator that this man is not of the appropriate integrity.
Teachers can't.
No, if he has inherited, he will indicate. He has to make this declaration that this is the amount of property that I have inherited from my forefather. This is the kind of property I have got from my wife's side. That declaration will be there. So that will be, and this is the amount of money I have earned as serving as a teacher. So that may not be, as has fallen from your lordship, not for the purpose of deciding whether he is suitable to select other people in different posts of absolute honesty, etc. But one of the parameters, as I said. So what I am trying to point out to your lordship is that the exercise that has been put to test before your lordship is not as it seems. There is a huge time lag. That time lag gives an indication of the fact that the government did not succumb. The government did not succumb to the demands made by these organizations alone. The cabinet discussed it there, took its time to arrive at a conclusion. And then, after more than 1 month and 11 days, it took a decision that we are going to recall these appointments in public. What? But if we straight away, if, one after the other, if you put the facts, it appears as if it is demand, tomorrow itself we have succumbed and taken it. It is not. That is what I was trying to point out, which I could not perhaps clearly point out here. So it is
No, rest, everything is all right. Huh? But the only issue was the CVOs, stakeholders. That was the only, the rest is okay.
that because my difficulty is I am bound by the records of the I cannot improve upon it. I am the last person to try and improve. Whatever is there before you.
And had you not appeared in this case, other law officers had appeared. I mean, this court may not have put these questions. Since you have appeared, we have put this question.
But it is always these are the occasions that we get to learn. It's always a learning process. So these debates and these deliberations what teaches the person more.
Yes.
So therefore, in my respectful submission, on both counts, the challenge is only on 2 counts. First is that you cannot remove me except following the riders of 370, which is not even applicable in my humble submission. And so far as the ground that the reason, it's an irrational reason. It is a arbitrary reason. That is not an automatic effect of the agitation, so-called agitations that have been recorded. Now, my learned friend has placed reliance on Mr. Mazumdar yesterday. He placed reliance on one judgment, 2023 SCC on that. I will just quickly distinguish these judgments.
Okay, that is section 21 of General Clauses Act.
He wanted to submit that it has to, even if you exercise your power under section 21, it has to be within the scheme of the act. What it says is
Which act? In the instant case,
the relevant act.
okay, the constitution in the instant case, the constitution. Okay.
And according to him, since the constitution does not provide for any other mode of removal, so you have to follow precedent.
270.
So that entire first scheme, that submission itself is founded on the premise that appointment and entering into the office are one and the same. So therefore, that analogy will not even come. And secondly, in that very judgment, at paragraph 27, I think he was relying on. Your lordship will find that when the Supreme Court says that you will have to be within the confines of the scheme of that particular act, the relevant act. The other thing that the Supreme Court has said that it cannot be repugnant to anything in the act. So here, that analogy again will not come. For the simple reason there is nothing repugnant to the Constitution.
Because 317 will not be applicable.
Not apply. Therefore, section 21 of the General Process Act will have automatic application.
Okay.
Now, my learned friend placed reliance on one judgment pertaining to, I think,
No, is there any parameters for exercising the power under section 21 of the General Clauses Act? You can just simply pull back the order. Okay.
So what he wanted to say is, since there is nothing in the Constitution, although you might be exercising your power under section 21,
but just a moment. Although this is not a service matter, in a service jurisprudence, when an appointment order is issued, you can't cancel it No, just when selection is made, you can't deny the appointment without adequate reasons. This is the general principle.
But selection does not automatically confer any right.
Though it does not confer any indefeasible rights
Context of service.
in the law. So there also, though that will be a select list, and appointing authority is also, in that case also the selection authority may not be able to pull back the select list in exercise of under 21.
But the appointing authority can. Like, for example, I pointed out the PWD rules, and most of the rules, service rules provide like that. Assuming for some reason there is a joining time, once an appointment order is issued, there is always a joining time. Normally,
should it not be for adequate reasons, or you can just pull it back on the non-happening of the event is specified?
It will depend on the outcome of the factors. Like, just to again hypothetically, I am also thinking about it. Assuming a person is appointed as some government post. After the appointment and before he joins, he commits a criminal offense. That is why I was recall the law relating to provision. Although it is a substantive appointment otherwise, after a selection and legitimate order of appointment, there is still that period of probation when the order can be recalled. A simpliciter termination can be issued. That power is retained for the simple reason there can be a multitude of eventualities. Like, as I said, a person is appointed, but before he joins, he committed a criminal offense. And when the employer thinks that I don't want to take him in service now, will the employer have to, even before he joins, will I have to follow the guidelines of Article 300? If it is stretching it, in my humble understanding, it is stretching it a little too far.
So, but in the instant case, you have tried to justify the recall order on the ground that there was an overwhelming public demand.
No,
for
that is the triggering point.
Okay. See, according to you, that you tried to justify the decision of the cabinet in recalling the appointment order by contending that there was a triggering point. Triggering point in the form of overwhelming public demand for recall.
The language used is that, I cannot improve upon. The language used in the affidavit is that. Overwhelming public demand.
So this, according to you, could be a justified ground for recalling of them.
No, that is not the ground. What happened was, like, I cannot, like in the case of the Allahabad High Court judgment, what was administered? Subsequently, it came to the
No, that I appreciated. Just because they failed to take all, you just pull back.
No, I'm not taking the example of the Allahabad High Court for that purpose. I am taking the example.
The Allahabad Calcutta was for the first limb of argument. 317 will not apply.
No,
they are yet to enter the office. So therefore they are not yet a member of the PSC. 370 will. Those decisions were not for the second one. Just pulling that.
I was drawing the example from those facts to say that even as high an office as the High Court of Allahabad was not aware of a constitutional amendment. So someone must have brought it to their notice. So here is the situation. This was our attention was drawn to this aspect on 17th of February. On 18th of February, we gave them an audience. The Chief Minister, along with high officers, including the Chief Secretary, etc., they gave them an audience that, all right, tell us what is it that you want to do? That happened on 18th. From 18th, the issue went on till 29th of March. On 29th, ultimately, the cabinet sat and said that in public interest we are. So those intervening days, every day, it is not that the government was sitting idle. The government was considering it. So therefore, from their side, the effort has been to show as if there was an agitation, we simply succumbed on the very next day, we pulled back the appointments. No. That is not the case. All we did, like our High Court and the Supreme Court, in the case of the gentleman who was elevated as a judge, what did the High Court do first? We will examine the issue. For the present, stay the oath-taking ceremony. That is exactly what they did. The cabinet. They said, let us not precipitate the situation because if we allow the oath to be taken, we will have to follow the riders of Article 370. So instead of getting into that trouble, we are postponing the oath-taking ceremony while we consider this. That is exactly how the Supreme Court dealt with the situation. Postpone the oath-taking ceremony of the gentleman, and we will examine the matter and decide. Okay. And ultimately, it was decided to strike down. Had the oath-taking ceremony taken place, even the Honorable Supreme Court could not have interfered because of the riders of Article 124. He could not have been removed by way of a judicial order, only by way of impeachment he could have been. Exactly same situation. So that is what I am trying to point out to your lordship, that it is not correct to say that there was an agitation which simply succumbed. That is not the correct position. Had the cabinet decided on 18th itself, instead of deferring, had the cabinet said, all right, we are recalling to this, that would have meant succumb. That would have meant that there was a law and order breakdown. We took our time, we took time to deliberate at length, threadbare, over a period of more than a month. And on 29th of March, the cabinet said that yes, we are recalling the law. We will recommend recall of the law. So that is why, my lord, the facts have to be, in my respectful submission, the facts have to be taken into perspective as they are. And therefore, in my humble submission, my lord, it cannot be said that this is a decision which is totally so irrational, so unreasonable, that no prudent man could complete. And to the extent that your lordship will exercise the extraordinary jurisdiction on the order.
Yes.
That is my.
So whatever the requirement of having a guidelines for.
That my lord, yes, your lordship has almost split my mind. I have been instructed. Your lordship is absolutely right, my lord. In fact, as an officer of the court or as an advocate general of the state, I cannot but say that having a set of guidelines will be ideal. I can also take up the issue with the government. And in the meantime, I am told there is a very specific to this point, PIL which has been filed. Exactly raising this point.
No, that is for the future. That is for the future then. In the instant case, if we find that there was no any guideline.
We are producing the report.
That will be known from the records. If we find that there was absolutely no guidelines or parameters for selection, and since the Supreme Court has said that there should be a guidelines, so should this court record some findings on that?
That is, so far as the permissibility thereof is concerned, as an officer of the court, I cannot even venture into the area. Your lordship has immense powers. Under Article 226, the powers are very wide. Your lordship sees that there is something which is not acceptable. Your lordship certainly can. I am the last person to say. That is why, and it has already fallen from your lordship, but I need not even place the judgment. Para 4. If your lordship sees that there is any injustice, even incidentally your lordship can. But in the incident case, I don't know. It is my duty to point out to your lordship that on this specific issue, if we are
is
Okay.
also pending.
Hmm.
So
All right. Yes. Now, what is to be done?
10 minutes to reply, my lord, on the next day I will do, because on facts, my lord, lots have been pleaded which are not in the affidavit. So I would like to, that's why I was reading the.
Which one? Which one facts?
Regarding, my lord, there was a deliberation conscious decision a month thereafter it has been.
Oh,
taken.
no. Deliberation is not on the record, but he's saying that because there was a passage of time.
Yes, yes.
So there was,
That's-
that is why there
that's
was a
why.
deliberation.
By way of
Ah.
my annexes, I will show that is not the fact. On next time, take hardly 10 minutes. Only 10.
anyway, Mr. Mozandar was suggesting some, I think it is unrealistic. Can it be 17? 16. 16 July. Let it be on 16. It's coming again on 18 for some matters. So if 17 would be ideal. If required also for population in 18.
Then we'll keep it on 18.
My typical way is maybe on the 17 is, yes,
Huh?
17 is okay for this matter.
For 7, but he has some difficulty.
16,
But you have, you,
I am coming back again. 14th I am here, 21st I am here. Any of these 2 days I am here.
14th.
14th also I am here and 21st.
He's suggesting 6,
17th.
17.
17th that becomes one of the something very important in telling. So then on 16th. 16. I will have the extended stay in that. Even we will have extended stay. All right, 16th then. I'll stay back. 6.
And otherwise you are coming on 21st.
14th also, 21st.
21st also. First is Monday. We can have it on 21st then.
21st.
Ah.
Can I get 16 or my 16?
Fine. Huh?
16th I'll stay back.
Today is what?
Today is
8.
8. We'll have it on 21st. Okay.
21st.
You said he is coming on 21st.
Coming down for 18th, one matter is coming.
Ah.
So Malad fixes on 16. We will stay back from 17 and we can approve the. 18th matter can be taken up on 21st. 18th that is fixed because the history.
You do you'll be here on 18th.
No, 18th.
Okay.
16th I think will be not difficult for.
I can agree to 16th, otherwise 14th and 21st I am here anyways. 16th I can agree to work with it.
Okay, all right. Mr. D. Pange, learned counsel for the petitioner in 213, WPC 213 April 2023, and Mr. I. Chaudhary, learned advocate general for the state. Mr. D. Mazumdar, learned senior counsel, appearing for the petitioner in WPC 223 AP of 2023, had advanced his argument on 7/8/2023, which however remained inconclusive as indicated in the order dated 7/8/2023. Also, Mr. Panging, learned counsel for the petitioner and WPC 213. AP of 2023 has also submitted that he will require. He may be allowed some time to reply to the arguments advanced by the learned advocate general. In view of the above, list the suit petitions again on 21st. 21st, we'll do it on 21st. Everybody will be here on 21st. Huh?
I think we'll see that difficulty on.
Oh,
I don't want to keep it partner.
okay, this will have to be partners, huh?
Yes.
Otherwise, okay. As a partner.
Oh, like.
If you're well.
Mason Mellon.
21st.
21st.
16, I think, I went to.
21st will be better. Means since Mr. Mazumdar will be here on 21st.
He will be here on 18th for some matter.
Then he will have to come on 21st.
But 16, I think, I'll see, my senior doesn't have a problem.
But the court has also to attend to, huh? Court is here to attend to all the cases, not only yours.
Absolutely.
Ultimately, the court had to say this, no?
Only it is not inconvenient.
Of course, it is not inconvenient, but yes.
My lord, item number 17, my lord.
Huh?
Item number 17, my lord.
Item number 17. This is not the only case. This is not the only case. There are other cases which is of immense importance.
I was just request.
We have several requests were made. We have considered. Ultimately, we have to pass this order. At one point of time, this court was also inclined for 16, but had to. It's a matter of 1 week only. It's a matter of 1 week only.
Yeah.
Yes. Yes.
My lord, item number 17, my lord.
Item number
17, my lord.
17. Okay, where is the coexist? Okay, let us do one thing. All the leftover matters, we'll list it tomorrow.
Yes, madam.
Huh? Okay.
Yes, madam.
All leftover matters.
There is only more than my lord.
Number low 33 low.
If
this can be list day after tomorrow.
33.
33 low.
For review.
Close.
Okay. 33 is faithful by Mr. Papin. List it, give the date after tomorrow.
Item number 20, my lord. Entry may be continuing tomorrow, my lord.
Which one?
20.
20.
Yes, sir.
Okay, in item 20.
Tomorrow.
My lord, item number 25, my lord.
Ah.
May kindly fix after 4 weeks.
Item 25.
25, my lord.
Where is item 25? I have not been able to locate. My list is, it starts from 29. What is list? Oh, yes, 25. Okay. Who is for the government? Have you filed affidavit? Have you received instruction?
Actually, my
Ask
lord,
Mr. T. Huh?
in this respondent number 4, it should be DC Anini, my lord. Actually, they have
Is there any interim order?
no.
Okay, you forget about it. Ask Mr. T. Dada, Learned counsel for the petitioner, and Miss K. Wangmo, learned government advocate, who pressed for and is granted 8 weeks time to file counter evidence. List it after 8 weeks.
My lord. My lord, item number 23, my lord.
23.
There is another analogous matter, my lord. That may be list together with this
23.
We'll pass that order tomorrow.
My lord, in item number 17, there is interim order that may be continued, my lord.
Huh?
In item number 17, there is interim order that may be continued.
Item
Number 17.
17. Then we'll take up the matter today. Otherwise, there will be a common order. Please, all these matters tomorrow. If some order is to be passed, then we'll have to take up the matter.
That is better. So whoever wants to mention, let it be mentioned tomorrow. Let all court is.
You don't worry, court is prepared to sit till the items are over. Those whoever are interested will take up the matter.
No, my lord.
It's not a question of 4:30. We can sit anytime. Yes.
Government still April has not been filed.
Item number
17.
17. Yes, who is appearing in the 17? What is the matter about?
My lord, there is a tourist lodge which has been given in lease to me, my lord, and later it has been cancelled. That was the case, my lord.
There is a stay order.
Yes, there is still.
We will not extend the stay order. What is the rent you are paying for lease pay? On for how much you have taken on lease from which department? Tourist department.
Yes.
Tourism department.
And meter we list tomorrow.
Mr. O. Dugong, counsel
Meter
for
we
the,
list tomorrow, my lord.
for the petitioner. Yes.
B Kamda.
They come to London Standing Council for
Tourism.
Council.
Tourism
You are
department.
receiving council
On behalf of M Pada.
on behalf of L. Pada. Have you received instruction?
Not yet, ma'am.
Who press for and is granted further 6 weeks time for filing of a counter affidavit. Also, having regard to the nature of the issues raised in the writ petition, however, the
Meter may be list tomorrow, my lord. My lord, I'm not.
whereby the tourist lodge,
Yes, my lord.
is it, where, which place?
Pasiga.
Tourist lodge, Pasigat. Having taken note of the manner in which the tourist lodge at Pasigat of the tourism department has been leased out to the petitioner on the rent. What is the rent?
And this.
What is the rent?
My lord, tourist lodge.
Rent.
This is for a 1,60,000 per annum for the period of.
My lord, I'm
For only rupees 1,60,000 per annum
For a period of 30 years.
for a period of 30 years.
my did.
Huh?
My lord,
30 years.
this meter may be list.
I
tomorrow,
am
my
not
lord, please.
inclined to extend the interim order
My lord,
as earlier. Also,
My senior will be appear, my lord.
accordingly,
My lord, my senior will be appear, my lord. Tomorrow, at least my lord, give me a tomorrow, my lord.
see, when you stand up here,
Yes, my
you
lord.
have you have to face the, when you open your mouth standing up here, you have to face the, you should be at the same time ready to face the consequences. Accordingly,
My lord,
interim order pass earlier instance vacated, listed after 6 weeks for filing of the
my
contract.
lord,
Yes.
I may be hard, then my lord. Then I may be hard, then.
Anybody else? Mr. Dugong,
My lord, this my lord, my senior case, my lord.
don't imitate your senior blindly.
My lord, then I may be hard, my lord, then I will submit my lord.
You have opened your mouth. We have heard you.
My lord, I will submit my point, my lord.
Yes,
my lord.
tomorrow.
Yes.
Your case will after 6 weeks.
My lord,
See,
give me
Mr.
tomorrow, my lord, then
Mr.
I will
Mr.
place my point, my lord.
Mr. O. Dugong,
Yes, my lord. I'm very sorry, my lord, for insisting, my lord. Extremely sorry, my lord. Extremely sorry.
Mr. O. Dugong, you are a young advocate.
Yes.
You have a long way to go. You have a long way to go.
Yes, my lord.
All advocates are supposed to be gentlemen.
Yes, my
Officer,
lord. Sorry, my lord.
you have to learn from the seniors. Don't follow the senior blindly. Apply your mind in each stage. That will help you.
My lord, then my lord, this matter may be list tomorrow, my lord. I will submit my point, my